All right. Again, I'll take that as comfort that we're all okay in terms of conflicts for these matters. Now, in terms of the Zoom protocol, you'll just see perhaps a notice that's come up that the hearing is being recorded, as are all of the hearings. It's actually a pretty cool way of recording hearings for future reference. Normally, in my experience with large hearings, there's a transcript that is kept and typed up and circulated around, but the fact that we can do this over Zoom and have actually a clear record is both very efficient and certainly very helpful to us as a panel. But in terms of Zoom protocols, please turn off your mics and your videos if you're not participating at the present time. That just helps us with the visual and the audio management of the hearings. I have to admit that while the Zoom hearings are very efficient and we're getting through our business, they do add an additional layer of sort of concentration needed, particularly by those participating and for the panel. So we'd just like to just keep it as calm as we can with just the one-on-one video presentations. I won't be using hand signals again, because there's normally too many people to see on one screen. But if you do have something you'd like to raise, you can do it by texting or emailing Julie, our hearing administrator. She'll text me if there's anything particular. I just turning off my own noise in the background. Yeah, so if there's any noise in the background, just manage that as best you can, acknowledging that there's probably in a few of your households kiddies running around and wondering why mum or dad are sitting closeted away and not available. And look, we'll be pretty relaxed about anything like that. That just comes with the situation. If you are having, so if you do, the other option in terms of just interposing is, I'm happy enough for you to pop in with a video and an audio acknowledgement to me saying, hey, there's something that you'd like to say. It's something that we do allow and talk about it in the hearings room itself, so that's all okay. If you're struggling with technology and some people are in remote areas talking to us, I'll let you know if we're struggling to hear, and if it gets too difficult, just bail out and talk to Julie about some other arrangements we might need to hear you properly, because it's really important that we do have a fair and efficient hearing process. So that's pretty much the introduction on Zoom. Before noting appearances, there are, I just wanted to acknowledge that we have issued a minute 9, which includes our interim guidance regarding strategic direction objectives, and that can be seen under our minutes section on the council's website. While we won't be debating that across the keyboards, we are interested to hear from experts and other submitters on how that interim guidance may or may not interface with your cases as we move through the specific district-wide and area-specific chapters. It's a live piece of thinking. We haven't decided anything finally. It doesn't bind us, that interim guidance, or any of the parties or the council. So that's the context of that. Just overnight, or yesterday, late yesterday, we have issued minute 11, which relates to expectation that parties providing expert evidence are to make themselves available to us for questioning as part of the obligations under the Code of Conduct, which are implicit that if there's an expert providing evidence, they need to be available to explain their opinions, answer questions, and help the panel in that way. In my view, that does extend to parties who perhaps have an expert in-house who aren't taking the Code of Conduct, but are requesting changes over and above any that may be recommended by the 42A reporters. I don't think you can hide away from us using that technique if you're a party that do come from a professional background, are recommending changes. So that's our position, and that's, I think, pretty clear in our minute, including the consequences that if experts just prefer to table the evidence, not make themselves available to be heard, we will not be taking into account their submissions in our decision making. Okay, is there any questions about either the interim guidance, the Zoom procedures, or our minute 11 regarding experts? I'll just take those now. Okay, seems like we're all good to go. I will note appearances for day 3 of hearing 4. So people that are online for the first time, or perhaps even weren't here yesterday, just to remind me who you are. We've certainly taken appearances for the majority of people I can see online here. So perhaps I'll just look at starting with what I can see. Nick Peiselman, I think you're new today.
Yeah, morning all. Nick Peiselman, I'm Todd Energy's Environmental Manager, and yes, new today. I was listening yesterday morning, but only a listening brief.
Welcome, Nick.
Cheers.
Just looking through, Tim Usher from Methanex is a new name.
Yes, good morning, Stephen. Tim Usher, Methanex, Senior Utilities and Environmental Engineer.
Okay, welcome, Tim.
Thank you.
Anthony, there's a name there I don't recognise.
Kia ora. Just a graduate planner for Lampro Limited. Just here to observe.
Don't say just, Anthony. It's great to have you, and I hope you learn a few things, and you're very, very welcome.
Sweet, thank you.
Nicola Lawrenson, I think. Nicola, we've talked to you before, haven't we?
We have, yeah. I'm the 42A author
sorry,
for Earthworks.
All right. My bad. And look, I think that's all. Oh, I've got a second screen here actually. Just looking. Oh, Mr. Quinn.
Yes, good morning, Commissioners. I'm appearing for Todd Energy and Todd Generation.
Thank you, Stephen. Anyone else? I think Tane, I can see there. You've been listening in, but I think you might be speaking us today on Nio. Hello, Nio.
Tēnā koutou, Commissioners. I'm Niall Marama from Methanex.
Kia ora, welcome. And Tane, can you hear me?
Ata Maria. Yeah, good morning, Commissioners. Yes, I have been listening, and yeah, lovely to see you all again today.
Kia ora. Thank you very much, Tane. Is there anyone else I may have missed? Cam.
Yeah, Ata Maria koutou, Cam Twigley from BTW Company. I've provided a brief of planning evidence on behalf of OMV New Zealand Limited, Ormata Tank Farm Operators, and Todd Generation.
Welcome back, Cam. Thank you.
Thank you.
All right. So moving along to, or are there any final questions before we get into the hearing for the day? Doesn't seem to be. So, Mr. Holswich, you're first up. So I'll just turn my my speakers off, and I'll let Commissioner Littlejohn and Commissioner Coffin take over for the moment. Thank you.
Kia ora mai tātou, tūtahi māku e mi ana kia koe e hira, I tīmatai tātou hui I runga ngā kupu te atua nā reira kei te mihi. I'd just like to acknowledge Sarah for starting us off this morning. Hoi anō he mihi kawana kia koutou kua tai tinana mai I runga tēnei ipurangi o tātou. He mihi kawana ki ngā kārangatanga kei Wainganui a koutou. So I'd just like to acknowledge wherever you're living or you're working today, I'd just like to acknowledge you all for gathering here today. O tira he mihi kawana kia koe e te rangatira Keith, ngā tira hiri, ko tai tinana mai ki te whakamārama ia mātau I runga ngā take o tira ngā awanga kei Wainganui a koe no reira kanui ngā mihi kia koe e te rangatira. And just like to acknowledge Keith ngā tira hiri for attending this afternoon and sharing his thoughts and his submissions with us today. Hui anō, he mihi kawana kia koutou, o tira he tukuna tirake kia koe Kit. Kit, if there was anything you wanted to say before we hear from Keith this morning?
No, just that it's good to see your smiling face, Mr. Coffin.
Just for a short time today, yes. Kia ora, Mr. Holsworth. Which we'll pass it over to you. We've read your submission. One of the challenges of this is I've got this huge myriad of faces and names, and I can see your face, but my eyes are not as great as they used to be. So if I look like I'm squinting, it's I'm just trying to make sure that I'm hearing the words and seeing the words coming out of your mouth.
Just Miss Antoine, if you go up into the right-hand corner, there's a little button view.
If you go to speaker one.
If you go to speaker, then it will
right.
Put the speaker.
That's great. I've got that. Thank you.
Sure, Mr. Coffin. Also, if you right-click on somebody's image, there's an option to hide everybody who is not speaking, and you'll end up with just 4 or 5 people across the top of your screen. Mr. Chairman, Commissioners, tēnā koutou katoa, and kia ora to all the whānau who are listening in. Good morning and greetings to you all once again. My name is Keith Holswich, and I've been asked by my hapu to represent them at these proceedings. Mr. Coffin, you've noted that you have got my speaker's notes and my submission. I will be using my speaker's notes to summarise the submission. So if you have both of those available, much appreciated. Our presentation today is in 3 parts, and they're in 3 parts with noise general matters, noise Methanex contour, and earthworks general matters. And I'm happy to present these in any order that you require, or I can just go through them as I've listed them.
Yes, that's fine.
Okay, thank you. If we get straight on to part 2 matters, noise, and as I've noted in my submission, we're very disappointed that we haven't had detailed consultation with council, especially seeing these 2 matters severely affect our traditional hapu lands. And in my submission and in my speaker's notes, I've attached a plan, map 1, that shows where our hapu traditional lands are in relation to the Methanex site and the general environment of North Taranaki. And I refer you to that plan during this submission. And as you will see, Mr. Chairman, we've only got 50 acres left of our estate, and much of that cannot be developed on. We've got nowhere else to go but this proposed plan to protect our sites. So we must and we will protect what little we've got left of our lands, and we will protect them with a passion. It seems to us that while we can agree on the objectives of the portion of this plan, the rules and effect standards at times contradict those objectives, especially when it comes to us being able to enjoy the undisturbed possession, peace, and quiet of our lands. If I can just pause there, and I note that Mrs. Marsh is online as well. Mrs. Marsh has been involved with our hapu affairs for the last 30 years, and I acknowledge Mrs. Marsh's presence this morning. Sorry, Chris, I forgot to acknowledge you this morning. As regards to noise, much of our concerns can be addressed if we simply move the Maori purpose zone from the noise S1-2 table, which is in the rural production zone area, and place it in the noise and open space table or the residential table. Now, Mr. Ellerton noted this yesterday in his talk, and if we can do that, then our noise issues, well, by far the majority of our noise issues will be solved. If that cannot be done, then there are lots of other matters that we have raised that we need to deal with. What we are concerned about, and I'm just going a bit off script here, is that no one, including all the presenters yesterday, seem to understand that we're going to be dealing with Maori purpose zone land, not rural productive land. Everyone talked yesterday about rural productive land. We have made a submission to rezone all of our lands. No one mentioned that. And we noted from yesterday's submissions, Mr. Peacock's comments that sound insulation is an option of last resort. And we noted your comments, Mr. Littlejohn, regarding a planning blight. And you may see the dilemma we are in, having small blocks of land right in the middle of major facility zones and oil and gas production zones in our province. I wonder, Mr. Chairman, I'm up to paragraph 6 on my speaker's notes, but I'm wondering if we can go straight to paragraph 6.3. And that is the effect standards. And Mr. Ellerton touched on this yesterday. And we request that our lands, we have requested our lands be rezoned, but they shouldn't be in the rural production zone table. We've all been on a marae. When you go onto a marae, it is not a rural production zone area. It's at the least a residential area. To me, it's an open space area. And the open space in residential areas afford us more noise control. There's less noise allowed to be made in those two zones. If we can simply change the Maori purpose zone into either the residential or the open space zone table, our concerns will be met. That is the easy way to get out of it. And our submission, we fully discuss the likely activities on the Maori zone that we're considering. And amongst other things, there's a marae site through housing, through education and business activities. They are hardly rural production zone activities. They are residential and or open space zone activities. And I'm reminded of Orwai Marae in the middle of Waitara, which again would be put into the rural production zone. Shouldn't be there. As I say, Mr. Chairman, if that item 6.3 can be done, our concerns will be addressed. But I'll go through all the other matters that we have as well, if I may. And if I refer to item 6.1 of my speaker's notes, if we cannot change the zoning of our land, then we would like to add another objective. And the objective that we are saying there in our submission is that it should not be the responsibility of us as owners of Maori freehold, Maori customary, or Maori purpose zoned lands to have to mitigate against noise by others outside of our land area. Now that's a huge objective. I make no apologies at all for trying to protect Maori land. That is one of the matters that we've got to consider. We don't want to go down that line. If we've got to, then that's what we must do, add another objective. Mr. Littlejohn talked yesterday about the first in, first served principle. Being the youngest of 3 boys in my family, I was always raised with the first up, best dressed principle. But surely our 600 years of occupation of our land has got to give us more favour than our neighbours who have only been there for 40 years. We are certainly there first. The reverse sensitivity should not be put on our backs. It should be put on those who wish to make noise over our lands. On my speaker's notes, Mr. Chairman, 6.2, we note in rural noise R5, is there meant to be anything there? There's an activity rule that talks of erection of new building to be occupied by a noise sensitive activity, and there is nothing there. We just simply ask, should there be something there? And we'll leave that for council to deal with. 6.3 in my speaker's notes, I addressed that at the start. If we can rezone our lands, we will be happy. 6.4. This is regards to well site drilling. Again, if we can rezone our lands, this matter will not need to be addressed. But you have seen a map that we produced that shows that there will be a drilling well within 50 metres of our proposed marae site at the end of Epiha Road. That is going, the noise from that well site is going to affect us unduly. And quite frankly, Mr. Chairman, going a bit off script, we're very tired of hearing over the last 20 years or so that gas and oil is where you find it, and that's where the well site must go. But nobody ever tells you that with directional drilling, a well site can be hundreds and hundreds of meters away from any sensitive location. The only difference being is that it costs money. In the same breath, we're told that farmers like to have such activities in corners of paddocks due to disruption. And I make the same observation as before. Well sites can be established anywhere. It just costs more money. And slightly off topic, and Mrs. Marshall will remember this situation very clearly. I'm reminded of a question asked of my kaumātua many years ago about how close a well site can be drilled to an urupā or a site of significance. And I believe this was at an Environment Court hearing. And after very careful consideration, my kaumātua advised Australia. That is how we feel about having to deal with oil and gas companies in our area. And I must at this stage, Mr. Chairman, say many of the oil gas companies are very good corporate neighbours, very good, and I include Methanex in that. Some are not so good. Item 6.5 in my notes, Mr. Chairman. We've noted that perhaps the Maori purpose zone should be inserted and used in several places in the rules. And we note that in the rules, every other zone is mentioned: rural production zone, future urban zone, rural lifestyle zone, residential zone. The Maori purpose zone is not mentioned anywhere. And we make that observation and ask council to consider whether that should be there or not. We're not planners. There's planners everywhere that can discuss this. We just make that observation. And in summary, as this first part of the noise section, Mr. Chairman, we expect that our neighbours should not be able to create excessive noise affecting our lands. But if they wish to do so, then it should be they and not us who should be responsible for any noise mitigation with respect to our lands and our buildings. Before I move on to the Methanex noise contour, Mr. Chairman, I'd be happy to take any questions on this, or I can carry on at your request.
Unless I hear otherwise from Commissioner Littlejohn, I think we'll hear your submission and then we'll ask some questions.
Thank you, Mr. Chairman. The Methanex noise contour, again, I express our disappointment that council never consulted with us on this matter. In fact, when we tried to hold a meeting with them, they refused to discuss this matter with us and asked me personally to leave the room. We knew then that we were going to be in trouble with our submission. We can report, however, that after taking matters into our own hands and following extensive and very constructive discussions with Methanex and their advisors, we are satisfied with their assurances that appropriate mitigation measures can and will be put in place to protect our lands from undue noise. Accordingly, and as I mentioned yesterday to Mr. Dash, we withdraw our original objection to the noise contour. And I've attached for your reference a map 2, that shows the relationship of our lands to the noise contour. And off script, again, I must say, Mr. Chairman, Methanex have shown themselves to be extremely good corporate citizens in this situation. And I thank them very, very much. And I noticed that Mr. Riley is online. Thank you, Gary, for the work that you did in getting that for us. That's all I have on noise, Mr. Chairman. If we can go to general earthworks matters. Our original submission on this matter of accidental discovery protocols was to be dealt with via the sites in areas of significance to Maori section. However, we note that the earthworks section now talks about this, and we ask for your permission to discuss this here rather than later. It seems to be an appropriate time to speak to that. And once again, Mr. Chairman, we were not specifically consulted about accidental discovery protocols. I attended by far the majority of the Kaitiaki Hui, and I most certainly was not present when this matter was ever approved in its current form. Our concerns regarding earthworks are set out in our submission. And we believe that policy EWP4 should be moved to the sites in areas of significance to Maori section of the plan, and that's being more appropriate place to put that particular site, that particular section. If it must stay where it is, or wherever it does go, the following has got to be rectified, and that's the effect standards EWS5. The current wording shown here is unacceptable to our hapu, and we most certainly never agreed to this during any discussions at the Ngā Kaitiaki Hui. We believe the words are too prescriptive and may not reflect the tikanga of all hapu and iwi. They certainly do not reflect our views. Again, we were not allowed to talk about this with council, and would have been unworkable in several situations that Mrs. Marsh and I have encountered on past projects. We believe that rather than prescribe the details of what must be done, the plan should have a guidance note. And the guidance note should say that necessary protocols need to be established by mana whenua. They must be referred to in case of accidental discovery. And the guidance note also needs to set out what is required in these protocols. But the protocols need to be left up to each hapu and iwi to set their own tikanga standards. As a hapu, we would never be so brazen to put into this plan what our protocols are, as they may impinge on the mana of other iwi and hapu. So we have given appropriate wording in our submission that may satisfy everyone. And we make this suggestion based on the 30+ years of experience that both Mrs. Marsh and I have of dealing with such earthworks matters, where every site and accidental discovery requires a unique set of tikanga and protocol rules. You cannot write down a single set of rules for every situation. A project is started, the project should go to the project managers, need to go to the relevant hapu and iwi, set the protocols in place, and those protocols are followed. And we believe the district plan should simply say protocols must be prepared, rather than describe in detail what those protocols are. In conclusion, Mr. Chairman, I believe that the particularly good start that Council made on the plan update process has hit serious speed wobbles with both the noise and earthwork sections of this plan. No doubt because we have had no direct input into these specific matters, and indeed we were not allowed to discuss some of matters with Council. And going off script a bit, what we are seeking here in our submission is to have full undisturbed possession, use, and rights to develop what little left of our land we have. Mr. Chairman, the proposed district plan is our last line of defence. We respectfully ask for your help in these matters because Council don't seem to be interested with our concerns at the present time. We look forward to participating further on this plan update, and once again to everyone and to all you commissioners, we acknowledge your presence on this hearing panel. Tēnā koutou katoa. Kia ora, thank you for taking the time to listen to us. And if I may, Mr. Chairman, at this time publicly thank Julie and the Secretariat team for the wonderful work that they are doing under these very trying circumstances. Julie, the work is very much appreciated. Thank you, Mr. Chairman. Happy to take any questions.
Thank you, Mr. Holswich. We'll ask some questions shortly. I suppose I'd been asked to come and be part of this hearing because you've heard earlier our chairman, Commissioner Dutch, had a conflict of interest regards Methanex, and I know your submission covers both those matters, particularly with noise related to the Methanex plant, but also earthworks, which I'm not specifically part of the hearing, but I'd probably just asking for you to sorry, what I'm trying to say is that I'll also be sitting on the hearing for the site significance hearings as well. So it makes sense that I've heard your submission both on the noise and the earthworks, because there are matters there that relate to the accidental discovery protocol. So I'm I suppose I'm just noting that because they'll be linked. I'll be hearing those at a later date.
Thank you.
Mr. Littlejohn, did you have any specific questions that you wanted to ask?
Yeah, thank you. Tēnā koutou, thank you for your evidence. I want to, I'll come back to the noise ones, Mr. Holswich. The request about moving the reference to the Māori purpose zone around within the rule tables of the noise is one, as you mentioned, that Mr. Allerton sort of framed up the other day. And I guess the starting point for my sort of thinking about this is what is the expectation of the land use that is going to occur in these zones? And you've helpfully given us in your speaker's notes, where is it? A plan, second to last table, second to last page 5, which shows the Hapu reserved lands as about a half a dozen, well, slightly more parcels. Are those all Māori purpose zoned land?
Not at the moment, Commissioner.
Okay.
They are rural production zones at the moment. We have made a submission on this plan to convert those to Māori purpose zones. For some reason, they were not included in the plan at the time.
Is it, and I guess this is the question, when we're talking about managing noise, we're doing it for two purposes. One we're doing it so that, and you'll see it in the noise rules, that there is a limit to the amount of noise that can be generated within a particular zone. Okay, so that's to protect land adjacent to your land use from the noise that you may create. And then you have another side of it as well, which is where land adjacent to yours that might be zoned differently also has that sort of control. So you'll see within the noise rules that they sort of operate from two sides. And I guess the thing I'm interested in is it the case that every parcel of Māori purpose zone will be used in the same way?
Absolutely not, Mr. Littlejohn. There are, as I mentioned, there are many parcels of that land that are designated as Urupa sites and cannot be used for anything other than that. There are 1, 2, 3 areas of land that can be used. 1A, 3E, and 6G are the only blocks of land that can be used. The others are Urupa sites.
Okay. If you bring the Māori purpose zone into noise S15 and make it have the same noise output as the open space and recreation zone, and I just wanted to make sure you understood this, it would mean that on that open space, on that Māori purpose zone land, between 7 AM to 7 PM, the maximum noise that could be generated from that use would be the 50 dB. So by bringing the Māori purpose zone land into that same category, you are effectively reducing the amount of noise that can be generated on it. Whereas at the moment, because it's up in standard S12, it gets the ability to generate up to 55 decibels during the day in circumstances where it's got rural production zone land around it. So do you understand the implication of shifting it around on the table, which is what you've said is your key thing that you think will solve your issue, is you actually place a greater degree of constraint on the land because it would limit the amount of noise you could create on it.
Thank you, Mr. Littlejohn, and you've enlightened me on something that has completely gone above my head, in that I was reading that to mean that nobody else could make noise in our zone, and you've enlightened me to say that we can't make the noise in our zone. And quite clearly on some situations, we do need to make a bit of noise at Tangi and everything else. We do need to make noise. And I will have to revisit that. You've enlightened me. I thank you for that. I have been barking up the wrong tree, I think.
Well, no, I mean, I think I can only sort of come to that sort of analysis of them because I've been working with these sort of rules for 20 years, and I accept that that they can be quite impenetrable to the lay person. Just coming back to your last point about tangi and the noise of crowds, there's an express exclusion of crowd noise. So, for example, if you did develop a marae on one of these blocks of land, and there was a lot of waiata and haka, for example, then it could be the case that that noise wouldn't actually be controlled by the noise standard because it's crowd noise. Although at the moment the exclusion, and I'm looking up at the start of the rules, is only for crowd noises at parks or reserves. So there could be a case to be made for including crowd noise at on a Māori purpose zone, for example, back up in that exclusion. And I'd have to have a sort of a think about that and check to see whether there's any scope for that. But I guess coming back to how the noise standards are written at the moment, if you go into your noise S12, subset 2 says, and this is, I guess, where there is an argument at the moment about the notional boundary, but it also says that rural production zone land, and someone will tell me if I'm wrong here, is not able to produce or be louder than 50 decibels within Māori purpose zone land. So that's your major control, as I see it. That rule 2 means that any neighbour of yours to Māori purpose zone land has got to minimise their noise so that it doesn't exceed more than 50 decibels at your site.
Yes.
Okay.
I think one of the ones we were talking about was that shoulder timing that people were talking about, the 7 p.m. to 10 p.m. Of 45. We agree with that, but we would certainly like any noise on our land to be less than that 40 dB between 7 p.m. between 10 p.m. and 7 a.m. Especially since the Māori purpose zone gives us things like kaumatua housing, gives us educational facilities, and the peace and quiet of a marae on the evening time. So that's what we're trying to achieve, is the lowest possible noise over our land.
Well, I think, I mean, I absolutely support that objective, but I think what you've already said is that not all Māori purpose zone land will be used in the same way.
Correct.
And so it becomes quite difficult to have a one size fits all standard where you might actually want to use some land for productive use and run it with a bit of noise and a bit of equipment on it to generate revenue. And I guess that's the challenge. The other sort of challenge I think you have is, having looked at your submission on the noise chapter, it's quite specific to the location of the Motunui noise contour. You don't unfortunately get into a lot of these bits of detail, and that's something we're going to have to look at carefully as well, particularly for some of the aspects of the relief you've sought. The earthworks one, and if you pull up the accidental discovery protocol, I mean, I've no doubt that you might have not had any direct engagement on this provision. Again, a difficulty we have is that I can't see us anywhere where Ngāti Rahiri has made a submission on this particular standard seeking that it be different. But you know, I'm going to take that and put it to one side, because I still think that some of the matters you've raised are possibly achievable within the context of it. The difficulty you have with this standard is that it's got to be crafted as a standard. It's got to be objective, and it's not able to reserve a discretion to a third party. So it needs to be very black and white. And I think what you've actually recommended for some of the changes sort of offends against that general principle by having a rule which says that you have to do earthworks in a way that the local mana whenua say that you ought to do them is probably not something we could incorporate into a resource management plan. It would have to be written in a different way. So I just wanted to reflect on that.
May I ask if you
Yeah,
grasp what it is that we're actually trying to achieve, and that is we don't believe a one size fits all will work, and especially with Mrs. Marsh and I and the work we've done and for the last 30 years, I think we've had a dozen protocols, accidental discovery protocols for different projects.
Yep.
A one size fits all doesn't work. And now whether council's document needs to be, I don't know, narrowed down, expanded out, I don't know.
Well, I mean, the only way you sort of address that is you have an accidental discovery protocol that relates to where the earthworks are happening and who the local hapu is. And then you end up with 10 different standards in the back there of the plan. So I fear that we do have to come up with at least a bit of a one size fits all, but there's no reason why it cannot be adapted to specific circumstances. For example, I don't know, have you got Earthworks Standard S5?
Yes, I'm looking at it now, yes.
So if you go through it's a 4-stage process. There's the stop work, inform, wait for an inspection, and then recommence.
Correct.
So
yes.
so if you look at 2, where you have to inform the relevant authorities, you could, for example, because at the moment it's only if the discovery is an archaeological site, Māori artifact or koiwi, that you would tell mana whenua. So you could potentially get rid of that qualifier and just say you will inform mana whenua regardless of what it is, so that mana whenua then effectively end up in the same situation as the council, that it doesn't really matter what's found. Mana whenua are informed about what's found. Now, mana whenua might say, well, look, hey, no, that's an old drill bit from the 19th century. We're not interested in that, and just let it go. But at least it's not up to the person who's made the discovery to determine what the nature of the artifact is. So that could be one thing you could adapt within part 2 to give greater information. The other one that sort of came to mind, number 3A, where it says wait for and enable an inspection of the site by the relevant authority or agency. You could also incorporate into that or mana whenua as well, so that again, mana whenua get the option of inspecting and having a look at the site and informing themselves about it. That's another idea I thought about, making this slightly more holistic. And then I guess the other one was coming down into the recommencement of work concept. And at the moment you see item 4 there. So these are preconditions before work can recommence. Where the site is of Māori origin and an authority from Puhiri Tonga is not required, the council will confirm in consultation with mana whenua that any koiwi have either been retained where discovered or removed in accordance with appropriate tikanga, and any agreed revisions to the planned works to be have been made in order to address adverse effects on Māori cultural values. So one idea that came to mind is to potentially enhance that proposition so that there's increased input from local hapu to the protocols to recommence work. And you could do that in a more objective way without offending any particular protocols that might arise from different tikanga. So I mean, those were some of the immediate ideas I had, because I thought your submission was well placed, your written material was well placed about making sure this protocol is as broad and involves mana whenua as much as possible. Are those sorts of things that you would see as improvements?
Yes, I think you talked about 4. We've got no issues with 4. It's just the protocols, what protocols, and we don't want to see those specific protocols in the plan.
Yeah.
We can't agree with those. If I can just comment here, the major developers in the area that we are, and that's the oil companies and all of that, we've generally got a good working relationship, and they allow us to be on site during all earthworks.
Okay.
So you know, we've got that good relationship. It's all we're dealing with then with these companies is what specific protocols must be followed when things are found. And that's a one-pager that we come up with before each project starts. I suspect we've got the oil companies covered off. It's perhaps the others, the earthworks. There's a lot of people now asking for huge amounts of earthworks to be allowed to be carried out. Those are the people that we need to watch out for, the farmers who now say, good, I've got 3,000 cubic meters of earth I can move in the next 3 months. We really want to be there. Every time people put a spade in the ground in our rohi, we're finding things. Every time. But I think, as you've mentioned, there's some things that you've said there that could really, really work. I thank you for your input onto that.
Yeah, the interesting, well, not the interesting thing, the reality is that this is a protocol that applies to permitted earthworks. So if someone needs to do more earthworks than what's permitted, then invariably they'll end up in a resource consent proposition, and then much more input from mana whenua would be expected, as would relationship agreements around specific protocols that would be very hapu specific. So this is the situation for stuff that's not regulated by resource consent. And in contrast to to first generation plans, there was never any such construct. Permitted earthworks, you just went and started digging.
Correct.
Whereas most plans now do have a permitted activity standard around accidental discovery, which has changed the world quite significantly just over the last decade, even in, particularly in Auckland as well, where this sort of construct has been introduced as well. Okay, thank you, Mr. Holswich. Thank you, Chair.
Thank you for your time, Mr. Littlejohn.
Thank you, Commissioner Littlejohn. You've done a really fulsome job in questions. I don't have very many others, mainly clarifications, perhaps. Can you hear me clearly, Mr. Holswich?
Yes, I can.
Oh, thank you. Just one clarification was around you'd mentioned in your submission and also in your evidence that there'd been no consultation on noise or perhaps the Māori purpose zone or wider issues. I just wanted a clarification about which matters you hadn't been consulted on, and which matters there had been some consultation, but not perhaps a fulsome consultation where you'd been involved in the completion of that work, perhaps.
I think, Mr. Chairman, we at the start at the meetings that we were held with council, which were very much appreciated, the general discussion of Māori purpose zone was presented to us. And I think everyone around the table, and Miss Benson, who was there at the time, will also agree with that. We took that with open arms. We thought that was a wonderful concept. And we all said that we were going to be involved with that. The next thing we've got is the plan is produced, and perhaps it was on us that we never went and forced ourselves upon council to ensure our lands were included in that zone. But all of a sudden the plan is out and we're not there. So that's why we've had to put a further submission in, agreeing with Te Atiawa that our lands should be included. And we were very specific with that, of what land should be included. And those are the lands that are on map 1 that has been presented to you. With regard to the noise, there was no discussion at all. And it was only because of, especially with the Methanex site, and it's only because we got off our butts and went and saw our colleagues at Methanex that that matter was sorted. There was no input from council at all. And as I've previously mentioned, the day I was asked to leave a public meeting was the day I realised that we were on our own.
Just turning mine to the specific sites that you've got in that quite useful picture. And I'll see if I can bring it. I've got it in, it's in landscape. So unfortunately, I'm going to turn my head slightly sideways as I'm having a look at it. There's several sites, and I just want to be clear about what I'm looking at. So there's 4 boxes, 4 red boxes, which are identified on that map. My understanding is that those are all Māori land. Is that right? Is that correct?
Which, can I ask which one you? Oh yes, indeed. The 4 red boxes.
Map
correct.
1, Hapu Reserve Lands at Motunui,
Yes.
and there's 4 red
Yes.
boxes. So those are all Māori land.
Correct.
Owned
Reserve
by
land.
reserve lands.
Yes.
And the 2 particularly that you've identified, the proposed marae site and the Waipapa Pa site.
Correct.
Are there any, can you just explain to me if there are any plans to develop those particular lands in those 4 red boxes? I'll just leave the marae site just for now.
The small red box at the top left, which is
Yes.
probably bottom left sideways, that is an urupa, so that won't be
Okay.
developed.
Yep.
The 1A block, that has got beneficial owners. So what they wish to do with that is up to them. We are simply trustees of that land, but the beneficial owners may wish to do whatever they do. And I'm not aware of any plans that they have got. The 3E block is currently designated as an urupa, but that many years ago was a site that was preferred during a hapu wānanga as a site for marae. It is not confirmed. At this stage, it's still up in the air. We have done preliminary works on that, survey works, design works. It hasn't gone further than a wonderful idea, but that has always been the preferred site. And on that same plan, you can see where the proposed well site is, which is just across the road from the proposed marae site. And that's why we've got concerns.
Yeah, and I've made an assumption here because I'm just looking at the map, but it's just the scale of it. There's currently no dwellings there. Is that
no
correct?
dwellings on that? No.
Okay.
And that's our concern, is that because we now may wish to put a dwelling on there, that we're going to be hit with everything that needs to be done. Although Methanex, that's part of our agreement with Methanex. Yeah, we've been there for 600 years, Mr. Coffin. Our neighbours have only been there for a short time. We've had enough of it. We've got nothing left, and we're still getting battered around the years.
I think that was a point well made, and it's interesting just you reflecting on some of the conversations that have been happening during the hearing earlier this week. And I think there are a number of other one-liners, use it or lose it.
Yes.
Yeah. First up, best dressed, I think was the one that perhaps you used, and others. I appreciate that. I did have another one. I'll just make sure I've got it here. This was just in regards to noise policy 2. I've just got a note just to check, and you'd made a note that there were going to be matters that are addressed at a later date, and I just wanted to be just clear about what those were.
Oh, yes, that's for what
21.
Yeah, and they were wanting to impose all sorts of noise contours as well, 100 metres or 80 metres either side of the state highway. And as you can see, especially with that 1A block land, the Waipapa Pa on the corner, if we've got an 80-metre buffer zone from the highway and we're included in the buffer zone for the Methanex, there's nowhere to build. So we just wanted to know and to confirm that we can come back and speak to that matter at a later time.
Okay, thank you.
And I think that's been deferred. That particular hearing has been deferred.
Yeah, I can't recall just offhand, but yeah, we can certainly follow that up. Just turning my mind to the earthworks, and I think Commissioner Littlejohn's actually covered most of the matters that I wanted to raise. I'm just going to bring up your submission again. And you just, it was helpful that you clarified that you were looking at less prescriptive standard there. And I couldn't help thinking, and it perhaps is very much in line with Commissioner Littlejohn, was that what you've asked for is that they could sit quite comfortably as objectives for accidental discovery protocol for the earthworks. But the standard, and Mr. Littlejohn has correctly said, it needs to be worded in such a way that it's quite specific and provides certainty, and it certainly I thought it does that. It provides very clear guidance in terms of these are the expectations for earthworks that might impact on accidental discovery, and it is within the context of a permitted activity. So it's I suppose it's an intervention that you wouldn't normally see. And I just wondered whether you just reflecting on Commissioner Littlejohn's comments, and certainly I'm certainly aligned with that, whether you had any reflections in regards to that, where in those cases where you wouldn't otherwise have an ability through the district plan to be able to intervene, there are provisions and specific ones that allow that.
I still think we've got a good relationship with the council with regards to earthworks. The planning people will get back to us. It's a hard one. And I note in the protocols at the moment, number one, cease works immediately within 20 meters of any part of a discovery. And Mrs. Marsh will recall on the Pauakura site, where one archaeological site was about 60 meters long by 40 meters wide. And that 20 meters wouldn't even cover it. And I think on that particular site, we were saved by the fact that we had a 50-meter radius. If anything was found, we had a 50-meter radius. Now, that is completely different than a farmer wishing to put a driveway in, where no other land other than 4 meters wide is being disturbed. You don't need a 20-meter radius around something that is found. You need an oblong shape down a driveway. Again, it's because of the prescriptive works, the prescriptive words that we just can't get our head around it.
Yeah, interesting. Oh, those examples are quite helpful, actually, just describing here some of the difficulties of implementing a very prescriptive standard. I think that was all of my questions. I'll just double check that if I had any others. That was all my questions. I'll just bring up our Commissioner Littlejohn, did you have any other further questions, clarification? That's a no. Thank you, Mr. Holswich. That's very helpful to us. There's some really interesting points you've raised with us today. Thanks again, and we'll look forward to seeing you in the future.
Thank you, Mr. Chairman, for your time today, and kia ora whānau.
And thank you for the little tips on the getting the different views. That's fantastic. Mr. Chairman, Commissioner Daish, is this the point in which I hand over the rako to you?
Yes, I've been listening in a very interesting discussion.
Yeah, and,
you know, I think the beauty of the way the council set the panel up is that we can bring other individuals in for specific topics. We'll be able to discuss some of the same issues with some of the other tangata whenua submitters later on. So certainly we'll keep you in touch on those matters. I don't think, well, I'm pretty sure Methanex aren't going to make any further comments, although there might just be if Gary or someone else just wanted to make anything in terms of just the acknowledgement from Keith, that would be allowable, I think, but it's over to them and to you.
Gary, you may just need to lower your microphone on your headset. I think it's just not coming through very well.
Sorry, thank you, Tim. Do you get me now? Forgot I had the headset on. Yeah, just I'd like to acknowledge Keith's words there. Thank you, Keith. We do treasure the relationship and look forward to working together to make things work in the future for us, for both parties. I was just going to point out as well to the commissioners that for the Omata tank farm subject, Methanex is one of the users of the tank farm. So up to you both who hears that, but just to point out that we do have interests there as well.
Yeah, I don't have, yeah, I'm just thinking aloud. So have you got evidence?
We're part of the Omata tank farm users group to which Cam will be speaking shortly.
Okay, well that is perhaps a connection I hadn't sort of joined the dots on. On that basis, I do think it would be appropriate for me to sit that out. I know it's Mr. Brophy's, was it Cam's giving that evidence? I think yes. And he's presenting some evidence on behalf of 3 parties.
That's correct.
So I wondered, just for order, whether Antoine, you could stay on for that matter and effectively, yeah, determine that with Kit as well. I'm just seeing whether you've got time to do that. I think Cam's up next, I think. Is that right, Julie?
We have Todd Generation and Todd Energy scheduled next. So
right. Well, if you could stand by, and when Mr. Twigley comes on, if you could join us again, Antoine and Julie will let you know. Is that okay?
Yeah, that's okay. I'm at home in the office, so I'm not going anywhere, and I'm just working on some other things as well. So just text me when you're ready, and I'll pop in. I'm probably not as prepared as I'd like to be, but that's okay. We'll
have a read of, if you can, Mr. Twigley's evidence. It's, yeah, I found it very helpful in the way he's integrated the 3 clients into one brief of evidence. He's done a really good job on that. So I don't think it'll take you long to get over the matters he's representing the tank farm on. So thank you for your help there, Antoine. Really appreciate it.
That's all good.
And thank you to the Methanex team too, just for being involved in this and listening in, and we'll carry on.
No problem. Thank you.
Right, so we now going to hear from, I think you, Stephen. You're leading this. Here we go. Yes.
Yes, good morning. Thank you, Commissioners. I've filed some legal submissions on behalf of Todd Generation and Todd Energy. Appreciate that they were, I think they just came through, but the intention was to go through just some highlights in terms of the matters covered off, rather than to anyway read those submissions. The first point I thought I'd note by way of overview, and it's not covered in the submissions, but I think we want to acknowledge and support the interim direction which has come out with respect to the new strategic direction regarding energy activities. That from my client's perspective is certainly supported. And I think in terms of the specific topics covered this morning regarding particularly noise and earthworks, that is integrated and related to that and consistent with it. So that's perhaps assist hopefully by way of overview. What the submissions cover off is some limited issues regarding outstanding issues regarding noise and earthworks. Dealing perhaps first with noise and then moving to earthworks. What I think is in agreement between Todd and the council officers is in relation to the appropriate nighttime level in the rural production zone. So we agree with the 42A recommendation in that regard, which reflects existing levels and in our submission is consistent with the national approach. So really the approach, the outstanding issue we're covering with respect to noise relates to the point of measurement. That's the matter and issue, that difference between the actual boundary versus the notional boundary. And in summary, our position with respect to saying that the appropriate point of measurement is the notional boundary of any dwellings is that we say that that is a matter of consistency, national consistency across most plans in terms of how the issue is dealt with in a rural setting. Secondly, we say that that deals with the noise effects at the dwelling rather than endeavouring to protect amenity across the whole of what's frequently a working farm. And therefore you're dealing with the amenity at the appropriate source rather than the farm as a whole. Bearing in mind that often in terms of a working farm, it's the farm itself is often a generator of noise. And I think you've heard some expert evidence already yesterday in relation to that, in relation to some of the noise that's generated from working farm activities. Perception that a rural area is a quiet area is frankly a fallacy when you look at the operations that occur in a farming environment. We say also that there's no explanation or justification put forward in terms of a change to take the point of measurement to the actual boundary rather than the notional boundary. And then lastly, we say that that approach in terms of dealing with these matters on a notional boundary basis is consistent with case law. We haven't provided at this stage in terms of the submissions to this hearing any analysis of case law, but to the extent it's of assistance, we could provide some examples to the commissioners, but there are certainly plenty of examples where that's reflected in provisions in other plans and been endorsed by the Environment Court. And then of course there's the last issue, perhaps in terms of reverse sensitivity, and that is something which we say can be addressed in terms of either plan provisions or consent conditions. In terms of particularly there's ways of dealing with date stamping matters, so that ultimately that deals with issues relating to new dwellings that might arise and the impact that might have in terms of noise provisions. So that is a quick summary in terms of perhaps the reasons that have been put forward and justification for that change. I should say that we do have on, and I think you've indicated earlier, Mr. Chair, that in terms of acknowledgement who was on the line, Mr. Peiselman on behalf of Todd is available and can talk to anything specific as it relates to the Todd sites and experiences that might arise. And following from me, Mr. Twigley, as part of the clients he represents, it also includes Todd, and he can speak to that from a planning perspective as well. So it's not just my legal submissions in isolation. The next topic I just wanted to speak to briefly in relation to noise is an issue that is not directly perhaps seeking any change, but has arisen in relation to the evidence which has been put forward as part of the 42A package, which is the expert evidence of Mr. Lloyd, and in particular 2 paragraphs of his evidence which specifically comment on Todd sites to provide a background example. And of course, it's one of the frustrations that lawyers have in these council hearings is that the moment that you see that type of thing being put forward in a brief of evidence, the first thing I'd want to do is have a nice discussion with them through cross-examination that might take a couple of hours in the Environment Court, but I can't do that. So I just wanted to make the point that that's certainly something that from Todd's perspective, we do not agree with the very quick analysis he's put forward. And in my submissions, I've quoted the 2 paragraphs of relevance there. what Mr. Lloyd has done is he's given a limited and I say kind of inappropriate description or examples in relation to some TOD facilities in relation to this noise issue. There's no full description given of the activities or the issues and frankly, there's no balance that's been given. And I think it's a reflection of perhaps the lack of examples that occurs in terms of justifying this as being a problem and justifying perhaps linking back to that point of measurement, the change that's been put forward. The TOD position is that those facilities do comply with the requirements of the plan and the relevant consents. But I raise this simply because I think it's just really a matter of record in terms of making sure that it's understood from a TOD perspective that those two paragraphs of Mr. Lloyd's statement are opposed. I appreciate that the role of the commissioners here, hearing these plan provisions, is not to get involved or try and resolve an issue as it relates to an on-site issue to do with complaints about noise on particular sites. I mean, putting it frankly, obviously there's no jurisdiction that you have in terms of those particular sites, but it is raised as examples and put forward before you as evidence, perhaps in relation to the appropriate nature of the noise provisions that are imposed. And I say in response that what's been put forward in those two paragraphs don't provide an evidential justification to change the point of measurement in terms of whether that be notional boundary or actual boundary. And in fact, I'd say that the council's evidence as a whole demonstrates that the noise issues in the rural zone are very limited, and therefore I would say endorse what I describe as the standard or normal point of measurement in terms of it being a notional boundary. Turning just briefly to earthworks, and I've hopefully set that out reasonably clearly in the submissions as to what's been sought and the justification for that, and certainly attached at the appendice to the evidence is the specific track changes that are sought to the provisions. But what we're seeking changes to here are to the earthworks limits relating to the volume of what can occur in terms of a permitted activity and the area constraints. In terms of volume, what we're seeking is an increase from the 1,000 cubic metres to 3,000 cubic metres. And the reason for that change in terms of volume is to align with the regional freshwater plan. And then in terms of area, although we've acknowledged that there has been an increase in that from to 1,500, what we're seeking is an increase to 2,500. And as I say, that's been, those changes are outlined in Appendix 1 to the submissions. Also outlined in the submissions is a comparison of, and this is at paragraph 34, a table there to compare what is the operative district plan permitted standard versus what's proposed. And you'll see what's proposed is a substantial reduction on where things are currently in terms of the operative. And that perhaps gives a little bit of context in terms of the nature of the submission and why this is a matter of interest to Todd. What we've endeavoured to do, and appreciate that some of this, I want to be cautious in terms of in legal submissions spraying too far into matters of evidence. So to the extent there are any questions in terms of Todd's operations, Mr. Heiselman can certainly address those. But I've endeavoured just to reflect as it relates to both activities, earthworks activities dealing with pipelines and well sites, some of the experiences and some of the kind of the background information in terms of those activities. Again, to give context as to why, from a Todd perspective, these provisions are important. And it is also against the background, and it is reflected in the submissions, we are dealing with very limited records in terms of complaints, very low number of complaints as it relates to earthworks. And again, that is important in terms of restrictions and whether more restrictive changes in terms of the operative, so the permitted provisions are supported on evidence. Hopefully, Commissioners, that gives an overview in terms of the TOD provisions. I'm more than happy to take questions for myself and Mr. Peiselman in relation to those matters.
Thank you very much, Mr. Quinn. And thank you for that introduction. And I don't have any particular questions for you, but I do have a few for Mr. Peiselman. Kit may well like to ask you some questions. So over to you, Kit.
No, I didn't. I just wanted to acknowledge that the two issues you've raised, Mr. Quinn, in terms of notional boundary and earthworks volumes and areas in the rural zone are issues that are squarely before us on behalf of other parties as well. So you're not standing alone on those two particular issues, where your clients aren't. So thank you for clarifying that in the submission, though.
Thank you, Commissioner.
Right. So, Mr. Peiselman, I've been. Yes. Hello there.
Morning.
Back.
Thank you.
You were listening in yesterday when we spoke to Greymouth Petroleum and Ms. Here. Did you hear that discussion?
I caught most of Greymouth's submission. I didn't hear the whole lot.
Yes. So there's three matters I'd just like to get some clarification from you on. It's really about sort of non-plan techniques that the company may or may not be or undertake when you're looking to site facilities with landowners, and whether, as a matter of course, through landowner agreements and other matters, you deal with some of the reverse sensitivity issues through, property agreements and other matters. Is that the sort of thing that you're involved with?
Yes. Yep. I'm party to that type of stuff for Todd Energy.
Yeah, and that is a non-district plan process which goes alongside the district plan rules, just looking at the reality of parties, neighbours, areas that you might be purchasing or leasing. Is that correct?
Yes. Yep.
Yeah. Okay. No, that's great. Yeah. Those two examples, and I don't want to, I think Quinn touched on the fact that we can't really take those sort of examples too far. They're not part of our evidence, but he's obviously concerned with the way they've been relayed to us. Were you involved in dealing with those examples?
No. I'm mandated to speak on behalf of Todd Energy. Todd Generation is a separate company, although they're related, so that they were Todd Generation issues.
That's fine. And just the comment about us being aware of, Commissioner Littlejohn and I being aware of the types of facilities that we're dealing with. I've had quite a lot of personal background in projects of your nature. And I'm sure Commissioner Littlejohn's aware of those too, but just to let you know that we have been asked to attend a site visit being hosted by Greymouth Petroleum, and we're going to find that quite useful. Just so to let you know, I'm not sure whether Todd has made a request for us to site visit. I think perhaps you have. So
yes, we have. Yep.
Yeah. Our position is that where we're asked to attend some site visits, we'll make every effort to do so. So we'll be in touch with you at the right time through Julie to organise that. So thank you very much.
Cheers.
So back to you, Mr. Quinn.
Thank you, Commissioners. That covers off everything that we wanted to cover through at this stage. Obviously, we are still linking in and relying on that part of Mr. Twigley's evidence as it relates to Todd, but subject to any questions, certainly that covers off the specific points for this morning.
Thank you very much. Look, I think we'll take a brief break. It's 10:30, and I've seeing the integrated nature of Mr. Twigley's evidence that does include the Tank Farms case. I've asked that Julie get in touch with Antoine to come back and listen through to that statement. So Julie, have you managed to get hold of Antoine?
Yes, he's currently online.
Okay. So yes, let's have a pit stop and we'll be back at 11:45. Thank you. Yes, hello again, everybody. I see Commissioner Coffin is there, so you might want to pop your head up too, Antoine. All right, so I think we're ready to hear from Mr. Twigley in relation to his statement of evidence.
Okay, good morning, everyone. Hopefully you can hear me okay.
Yes, sounds good.
Yeah, so my evidence is given on behalf of 3 parties. That is OMV New Zealand Limited, the Ormata Tank Farm Operators, and Todd Generation Limited. I'm conscious that the commissioners have had an introduction to OMV and Todd Generation, but wouldn't have had an introduction to the Ormata Tank Farm Operators. So I thought it might be useful if I just quickly outlined who that group comprises and the nature of the operations at the tank farm.
Thank you. Yep.
Yeah, so the Ormata Tank Farm Operators comprises Methanex, Beach Energy, New Zealand Oil Services, and OMV. And the facility is a 87 hectare site located in New Plymouth and used for hydrocarbon storage activities. It's connected via a number of pipelines feeding into the facility, but also linking or exporting down to Port Taranaki as well. Most of those pipelines are within Centennial Drive, if you know that area.
Yes, I think we've all got a pretty reasonable geography on where it is. Thanks, Cam.
Okay, great. The other thing I thought would be helpful is pointing out that OMV have interests in both the proposed major facility zone and the rural production zone under the proposed plan. The Ormata Tank Farm Operators only have interests in the major facility zone, and Todd Generation, their facilities are located in the rural production zone, but they have made submissions for 2 of their power plants to be zoned in the major facility zone. So they do have an interest in that aspect of the noise chapter as well. Just to try and clarify the differences between the 3.
It's helpful, thank you.
Yeah. Okay, so yeah, I'll just provide a brief summary of my evidence. It really focuses on the noise standards 1 and 2, specifically the noise measurement point, which you've already heard some evidence on. I was listening yesterday morning, so I did hear Mr. Higley and Ms. Carville speaking about that as well. And the other issue it relates to is the nighttime noise limits, which I note in the Section 42A report. They've recommended that they be 45 dBA at nighttime within the rural production zone, which my evidence would it supports that change. So yeah, the starting point for my evidence was really a reflection on the current operative district plan and the way that noise is managed in the rural environment area. And yeah, my evidence is really based on my experience over the last 15 or so years dealing with the operative district plan and the noise aspect of consenting. And my experience relates to the oil and gas industry, the poultry industry, quarries, but also land developers, subdividers, owners of rural land that want to develop it. So it's quite a broad base of experience that I'm reflecting on. And the thrust of my evidence is really, if it ain't broke, don't fix it. In my experience, the notional boundary measurement point has worked well in the district. And I've also reflected on the council's monitoring data related to noise, and I couldn't see anything within that data that that sort of reflected that there was a problem that would support a change to the current notional boundary approach. Looking at the council's reasons within the Section 32 report, the main driver for a change from the notional boundary, the sole notional boundary approach, seems to be that this notion that using the notional boundary approach doesn't allow for a consideration of noise on future, how it affects future development. So, that could be a landowner's desire to develop a second dwelling on their property, and the fact that that aspect couldn't be considered under a consent process. And that seems to be the major driver that I can see for the proposed change. So in my experience, I haven't seen that issue arise. However, I do accept the point that's made by the council that it could arise under the current operative district plan framework. And in paragraph 24 of my evidence, I've provided an example of what I think the council are getting at in terms of what that issue is. When I look at the proposed plan in terms of the way that it's the mechanics of it really compared with the operative district plan, there's a clear move from an effects-based plan to an activities-based plan. And I think that is quite a key point in terms of the issue that council are raising to justify the change to the noise measurement approach. So what's proposed under this plan is really that move to the activity-based plan. So, for example, something like a well site or a quarry would be considered as a discretionary activity, meaning that all and actual and potential effects can be considered by the regulator, and that's quite a key change from the operative district plan, whereby it's an effects-based approach. And if consent is required, it typically defaults to a restricted discretionary activity, where not all actual and potential effects can necessarily be considered. So I think that's quite a key change when you're looking at this issue about noise. I also took the time to look at the Court of Appeal's decision, Queenstown Lakes District Council versus Hawthorn, which I'm sure the commissioners will be familiar with. And I'll just read from that the decision. In our view, the word environment embraces the future state of the environment as it may be modified by the utilisation of rights to carry out a permitted activity under a district plan. So the relevance of that to this issue, in my view, is that within an activities-based approach under the proposed plan, and if council applied Hawthorn correctly, they would be able to consider the future state of the environment as it may be modified by the utilisation of rights to carry out permitted activities. For example, build a dwelling. So in my view, I don't think there's a void there that or an issue that would exist that would require a change to the noise measurement approach to address that particular issue. Hopefully that makes sense.
Yes, I certainly take that point. I've got a follow-up question when you finish. So
sure. Yeah. Another point I just wanted to highlight was the approach that's been proposed. I've referred to it as a hybrid approach. Using both the property boundary measurement point and the notional boundary. There isn't any background in any of the council documentation to say how they've come up with that approach, but I'm picking that it's been developed through the mediation that took place and the consent order that was agreed for the South Taranaki District Plan appeal on noise. And I just wanted to highlight that was a mediated solution to that appeal. In my view, I don't believe that it represented best practice or is a common approach that's used across New Zealand. Mr. Lloyd himself describes it in his evidence as a compromise solution. And I'd agree with that because I was present at that mediation. When I prepared my evidence, I did have the benefit of seeing Mr. Ellerton's evidence before I did that, before I prepared mine. And so I did see his graphic around the councils throughout New Zealand that apply the notional boundary approach. And it seems to me that the vast majority adopt the notional boundary approach within their rural zones. I also had a look at NZS 6802 2008 to take some guidance on the issue from that New Zealand standard. And my reading of that standard as a whole is that the default position is to apply the notional boundary approach, and that the site boundary approach should only be applied if special planning reasons exist. So looking at the council's reports, it's unclear to me what those special planning reasons are within the New Plymouth district that would justify applying a site boundary measurement approach. Another issue that I'd like to touch on is there's a comment in the section 42A report, paragraph 77, that talks about a further justification for the proposed measurement location being to address potential reverse sensitivity effects arising where new sensitive activities locate near to noise generators in the rural environment. Yeah, I'm unsure how introducing a property boundary measurement approach would address reverse sensitivity, given that those noise sensitive activities that are looking to establish don't typically emit high levels of noise. So yeah, I didn't quite understand that point about how a property boundary approach would address reverse sensitivity. But perhaps the council can explain that. So yeah, so after going through that exercise that I did and undertaking
Section 32A evaluation, my evidence is that retaining the existing notional boundary measurement position would be the most appropriate approach in achieving the purpose of the Act. And I've outlined the recommended changes for each of the submitters in separate appendices in my evidence. There was one last point I wanted to cover, which was my evidence did seek some clarity around the Methanex Motunui noise control boundary. OMV were concerned that there was some confusion around it potentially being a joint noise control boundary, but I did listen in yesterday morning, and it was clarified by the council officers that that noise control boundary relates solely to Methanex, so that point's been answered.
Thank you very much, Mr. Twigley, and that was one of my questions, that you were satisfied with that assurance regarding the combined boundary, so seems that you are. Look, I'd like to start with thanking you for your considered, thoughtful evidence and the way you've presented today, because you're anticipating many of the thoughts that we're grappling with, and I think it also highlights the benefit of experts and companies allowing experts to sit in on other parts of the hearing, just because we're all, as practitioners, we're running an inquiry-based hearing where we do want to get the best advice and hear from our peers, I suppose. So thanks for that, Cam, and also just the way you've set out, reasonably fulsome Section 32AA approach. It's certainly what we're looking for from our advisors, if you put it that way, in terms of particularly planning witnesses and other specialist witnesses. So that's just an introduction, and thanks for that. But in terms of specific questions I have, and I'll kick off this time, at your paragraph 20, you talk about the report which hadn't been made available, and I think you would have heard that information and other information is now going to be made available. My question really is do you think of that information is, or maybe of such note that you'd want to have the opportunity to respond to anything there, or do you think it's clear enough from the 42A report what the direction of council's travel is?
Yeah, I think the main point I was interested in was the monitoring data and getting some more insight. And there was an example given about a well site, I think, and I think it would just be more, it would be helpful to understand a bit more about that information that's being used to justify the council's position.
Okay.
I'm not necessarily saying it would change my evidence, but it is something that I would like to see, and I think Mr. Ellerton was of the same opinion.
So I wonder whether Holly or Julie or someone can give us an update. Is that on its way out to the parties?
I haven't received, Holly's online, she can answer.
Yes. Good morning, everyone. So yes, we have gathered those documents together. We are just checking with the parties that information relates to just confirm they're all happy for it to be released, but we should be in a position to do that shortly. So just confirming we have got all the documents together, and we would definitely on track for getting that out to everyone. Understand it's a key piece of information which the hearing parties are keen to see. So yes, we'll certainly keep making sure that we do get that done.
Thanks for that update, Holly. All right, moving along. just, Mr. Twigley, you mentioned that you have had quite a lot of experience with many of the projects around and about Taranaki and New Plymouth District. Were you involved in some of those ones that you record in paragraph 21?
Do you mean the noise complaints?
Yes, just if you've had any experience with any of those particular topics.
Yeah, well, there isn't any detail given about which sites they relate to. So yeah, I'm not sure.
Yeah. Okay.
Possibly.
Yeah. Yes. And maybe again the council, someone there, Holly, or someone else at council, your query about the example in the section 32 case, can we be enlightened about what that was about? Your paragraph 23, I'm just looking at.
Again, yeah, that's about as much detail as was in the section 32 report. So
yeah. I'm actually asking Holly or if she or one of the other council team online could enlighten us about what that was about. Is Hamish there, for example?
Yeah. I just look, Commissioner, this Hamish Wesney here. I was just looking that up. Can I come back to you shortly, just once I've reviewed that quote in the section 32 report?
That's great. Okay. And thank you. And my next question is about your Hawthorne quote and its applicability as a planning practitioner in hypothetical or maybe anticipated cases that might come up under the proposed plan, Mr. Twigley. What's your own view about future likelihood of sort of new activities being permitted coming in around about the facilities we're talking about under the proposed plan construct?
Well, it's, in my experience, it's not an issue that's come up very much at all. So it tends to be, well, taking the case of a well site, the companies tend to locate a site away from housing, if possible, away from the road. Quite often at the end of quite a long access track into the site, at a location that's been agreed with the landowner, because quite often these sites are leased. And as you can imagine, a farmer doesn't usually want a well site in their best paddock for obvious reasons.
Their own paddock.
Yeah. So quite often the sites are located away from locations where someone would want to build a house. And I think there was some, can't remember exactly who it was, but it might have been Rebecca here yesterday, spoke about houses typically, oh no, it might have been Mr. Higley actually, houses typically being located close to the road, for obvious reasons in terms of servicing and infrastructure and cost. So this issue about the probability of new houses springing up around these types of sites has quite low probability. But I think my point was that the council's position was that there's an inability to when looking at a consent application for a new well site, for example, there was an inability to consider the future environment. And my evidence is that I don't think that's the case. I think for each and every consent application, the regulator would need to consider whether they need to take account of the reasonably foreseeable future environment as it might be modified by those permitted activities. And then think about that on a case-by-case basis. Sometimes it won't be necessary, but sometimes it will. And if it is, then the mechanism is there legally to consider those issues.
Okay, no, that's fair. Then my last question really is about your paragraph 35 and this concept of special planning reasons. You're posing a question more for the council team, and their experience so far is that they've been pretty thorough about taking on board and responding to submitters' evidence points. So I expect they'll make some comment, but can you conceive of any potential planning reasons at all as a practitioner yourself?
Well, in a theoretical sense, it might be that you have a rural environment area that has a higher density of dwellings than you would typically find, and for that reason you might consider that there are special planning reasons that exist in that environment to use a property boundary approach versus a notional boundary approach. That would be one sort of thing or reason that springs to mind. But in the New Plymouth district, I'm struggling to see what those special planning reasons would be to justify a different approach.
Okay, well, thanks for that, and thanks again for your evidence. I'll hand over to Commissioner Littlejohn and then Commissioner Coffin after that.
Thank you, Mr. Twigley. I just wanted to take you to your Appendix A, if I could. I understand the rationale for your change to the first bit of S1, because that gets rid of that effectively reinstates the notional boundary as the sole proposition. In number 3, can you just explain the rationale for the changes there? Is that simply to adopt the same approach for the major facility and hospital zone? Is that all we're seeing there?
Yes, that's right.
Okay.
Specifically in relation to the rural production zone.
Okay.
So not applying that to the residential zone or any of those other zones, specifically just the rural production zone. Where that
any other site in the rural production zone. Okay. All right. And I see we've left in the shoulder period there. You don't have an issue with that? See the item C?
No. Okay. Yeah, the submitters didn't have an issue with the shoulder period.
All right. Going over the page to standard 2, and I must say this is the one that I was a bit confused as to what we were doing here. Why have you dropped out standard 2.4 for well site drilling?
With the notional boundary approach, if that is accepted, then there isn't. I don't see there's any need for a specific well site drilling standard.
Okay. 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 Let me just catch up. It's to 4. So what you're saying is that reinstating notional boundary as the sole compliance point means you don't need to differentiate well site drilling. It would simply then be controlled by reference to standard 1 or standard 1 effectively. Is that right? Okay. Okay. Now that explains that. That was all I had, Mr. Twigley. Thanks for clarifying that.
Thank you.
Thank you, Mr. Twigley. Good to see you again. I had 5 questions. I think 2 of those have been answered already. Those were Commissioner Dacia's questions. Next ones are just in paragraph 28. This is just in regards to rural noises. Hope I've got the right paragraph. Yes, the rural activities produce noise 24/7, and I was just wondering if you had any specific examples of what you were thinking.
Sure. Yes, I mean, this is in relation to oil and gas activities.
Okay.
So when a well's drilled, that is a 24/7 operation. And also a number of the production facilities operate 24/7 and emit noise 24/7.
So the noise produced from those types of activities in the rural area. Yep.
Yep.
Okay, thank you. The next one just regards the hybrid approach, and I just wondered whether you were aware of it being used elsewhere in New Zealand.
No, I'm not, but I believe the idea in the mediation with South Taranaki District Council with their plan process, I believe the idea came from one of the planners who was familiar with that approach being used in one other district, and I think it might have been in the Hawke's Bay somewhere.
Good. At paragraph 40, and this is quite helpful, you're providing the section 32 AA evaluation, and I just wanted just to clarify what you were thinking in regards to just a little bit more explanation about what you would think those extra costs might be using the hybrid approach, where there might be just special planning reasons for applying it. Those might be rare. So I was just wondering what you were thinking with the costs, where they lay.
I think the costs are, the unnecessary regulation, for a consent applicant, the uncertainty that using the hybrid approach potentially creates in terms of compliance at 2 different points. So that was the main issue there that I was trying to allude to.
Okay, thank you. I didn't have any other questions.
Right, so I think we're finished now, Cam, and thanks again for your help. We'll dare say see you again in future hearings.
Thank you.
So we're switching through now to Mr. Brophy for Blue Haven Commercial Limited and Southern Cross Hospital. And I think, Antoine, you're excused again.
Thank you. Have a good day.
Yep, thanks. Hey, Jeremy.
Good morning, Commissioners. Thank you. How I will look to proceed, I've provided some reading notes to Julie that hopefully you've got in front of you. But today I'm presenting on behalf of Southern Cross Hospital and also Blue Haven.
Just see if we've got those. Are they online, Julie? You'll need to do your speaker.
I'm that person. Not online. I just need to find them. Right, they came through first thing this morning. Was it this morning? I'll forward those through via email to commissioners now.
Thank you. We'll just hold for a sec while they come through, Jeremy. interesting to see which is the fastest wire, whether it's New Plymouth to Auckland or New Plymouth to Napier. There they are. Thank you, Julie. You got them there, Kit? Okay, so back to you, Jeremy. Thanks.
Excellent. Okay, thank you, Mr. Chair. So my in my summary reading notes provided, I have separated out Southern Cross Hospitals first. So perhaps I will go through that evidence first. The method that I've used is I've separated out the areas that I'm in agreement, and I won't spend too much time on that this morning, and we'll just focus in on the areas of or matters of disagreement with the 42A report author. So moving through to, what have we got there? Paragraph 7. So I guess there's one key area that I'm in disagreement with regard to Southern Cross Hospitals, and that relates to noise matters in relation to exclusions for generators specifically. So in my evidence in chief, I've provided a more detailed analysis of different aspects of Southern Cross Hospital, and how it would apply in terms of the use of generators. So in my opinion, the exclusions in the noise chapter that relate to the use of generators are currently open to interpretation. The current wording used with regard to generators is for emergency purposes, but only for emergency services and lifeline utilities. And whilst it is expected that Southern Cross Hospital's facilities are intended to be captured by the exclusion, as currently drafted, depending on the context, it is possible that Southern Cross Hospital's facilities may not qualify for this exemption. In paragraph 8 of my reading notes, the range of activities and potential emergency services provided at Southern Cross are described. Just have a bit of a list there. So I guess in summary, day-to-day operations at Southern Cross Hospital in New Plymouth for elective surgeries. So it's not an emergency facility per se in day-to-day operations. However, during a large-scale natural hazard or a disaster, or potentially a large-scale epidemic or potentially a pandemic with COVID-19, if it got out of control, Southern Cross Hospital would provide support to Taranaki Base Hospital in terms of emergency services.
Is that by way of an arrangement or a contractual arrangement, or just something that the hospital would step into the breach?
Yeah, I'm not sure what the arrangement is. Yeah, I'd have to confirm that with Courtney Bennett. But I can confirm what the arrangement is. I'm sure there probably is something a bit more firm.
Yep, that'd be good.
Yep. Excellent. And I guess the other, those are some emergency examples whereby Southern Cross could be required to assist. And the other one is an obvious issue if there was a power outage, which could be related to some sort of natural disaster as well. Obviously, there's hospital theatres and surgeries ongoing, and the need for the generators on site is also important for everyday operations. So that's the basis of how I would consider Southern Cross to be something that should be provided for in the exemptions. And then in terms of the submission provided by Southern Cross, there are a couple of alternatives for wording that could be provided for in the exemption. And it could either be by adding the word major healthcare activities, or potentially adding in the wording in the hospital zone, as I've included there in paragraph 14 of my evidence in chief.
Okay. Thank you. That's clear from me. So is that all you'd like to say about the Southern Cross hospitals?
Yes, that's all I've got for Southern Cross. Just the other 2 points in agreement, which don't need to be covered.
Okay. Look, I'd like to just thank you in the same way I did to Cam. I think the quality and standard of the evidence coming through is really good, and even this example here about where you're focusing particularly on matters of disagreement and highlighting them for us, it's hugely helpful as we deal with so much information. So just thank you for that. I do have a question about the generators on site. I presume there'd be, you may or may not have experienced that, in terms of backup battery generators, are they enclosed in buildings, or are they bundled, or do you know much about the ones that are there as backups?
Yeah, the generators they do have on site at the moment are quite centrally located, and they are inside a building. And I had turned my mind to whether or not there needs to be some exemption for those generators currently. And my understanding is that it's quite likely that they will comply with noise standards. I have been involved in some recent consenting related to expanding the hospital, which has assessed a number of matters in terms of noise. So I guess the submission and the evidence that I'm providing is more for a future expansion of the hospital, and or if there's a situation where the hospital is providing emergency assistance to base hospital, where there could be some temporary buildings set up in the car parking areas, or something that is done in a hurry and has some provision there to enable things to be done and for power to be provided.
Which could well be by these big mobile standalone generators that spring up when those sort of things happen.
That's correct. Yeah, that's it's part of the thinking with that evidence.
Okay, and just again a bit of local knowledge for me, the location of the two hospitals, from a hazard resilience point of view, is there any distinction between them that you might see Southern Cross more into play?
So do you mean between the base hospital and
Yes.
Southern Cross?
Yes.
I don't know if there would be too much of a difference. Southern Cross Hospital is a little bit closer to the coast. Yeah, I'm not really aware of anything that would be of concern. I think if there were issues, whether it be an eruption or earthquake, I think both would be on pretty level standing in terms of risk.
Yeah, okay, no, that's great. Well, that's all I have in the Southern Cross matter. I'll hand over to Kit.
Thank you. I just did one matter. I just wanted to check. I'm in your Appendix A, And you've suggested some amendments to the noise rules introduction to incorporate, and you've given us two options there, major healthcare activities or hospital zone as one of the exclusions. And I see that in standard 1.8, you've also included a note down the bottom. And I'm just wondering, is that just, is that for a different purpose than explicitly listing the exclusion of the noise rules at the start, or is it just a belts and braces sort of approach?
Yeah, that's just a belts and braces approach. In my evidence, I've sort of given three options. Yeah, being including the major healthcare activity wording, hospital zone, and then if they're not suitable,
this is option 3. This is option 3. Okay,
this is option 3, but not preferred. I guess is the key point.
I don't think it fits. I don't think it fits with the architecture of the way the standards are drafted anyway. I haven't seen any other standards that then have an exclusion right down the bottom by way of a note. So I just wanted to clear. So they're all sort of 3 different options to fix the issue that you've identified.
Correct. Yep.
All right, cool. That's all I needed to clarify. Thank you, Mr. Chair.
Thank you. Just to follow on, Mr. Brophy, your general position as a planner about things like advisory notes, explanatory statements, and plans. What's your general position on that type of drafting?
Yeah, I think my preference is for wording to be embedded in the standard and to be clear. An advice note is sort of something that tends to help the reader interpret the rule if it's a little unclear. So I guess it's certainly not my preference to have an advice note, but I guess it's just an alternative if the council planners and the committee are of a mind to perhaps look at that option. Yeah, certainly not my preferred option.
Yeah, good answer for me. It's a bit of one of my bugbears where you particularly perhaps get some national planning instruments coming out, and then there's 100-page guidelines about how we're supposed to interpret them. Just does my head in, but that's a by the by. We'll carry on. Blue Haven, you're moving to now?
Yeah, so in a similar way, yeah, in my executive summary reading notes, I've separated out matters in agreement and then into matters of disagreement. Yeah, in a similar way to Southern Cross, I won't go through the matters in agreement in detail. The one point that I will mention is, we've got there point 13, paragraph 13. It's just a point that was raised by Blue Haven's legal counsel, Ms. Barry Pacino, around a request for planners to complete some caucusing in relation to the sub-regional centre zone provisions. And I guess we are just sort of waiting back for some feedback from the panel on whether there's some agreement that this be carried out. In terms of providing planning evidence, it is a wee bit difficult given that I'm essentially providing evidence on the industrial zone rules and also on a potential sub-regional zone, centre zone set of provisions as well. So I see there as being benefit in caucusing those provisions and having a set there that could potentially be looked at if that sub-regional centre zone was to be progressed. So possibly a little bit of a side position, I guess, in terms of the other stuff I'm going through, but something of interest, certainly.
Let's just respond to that now verbally as best I can. Those hearings will be heard by Commissioner Littlejohn, myself, and Commissioner McMahon. We have been thinking and pondering about the best way of setting those hearings up, and we've had the request in the scope legal submissions that Ms. Barry Pacino gave us, and you've prompted us again, I'd like to hear back from the council planning team, or we all would, on their position on this before we do make any directions or do or not. And I think Sarah Woods isn't online, but whether Hamish, you're there and you could perhaps take a message, or Julie, that we would like some response just from a process and fairness perspective from the council team. There's two possibilities. I presume that they might say, well, look, we're pretty clear in our position and we think that that type of process may be helpful or may not be helpful in terms of advising us. Our position is that, as I said before, I think to Mr. Twigley, any assistance we can have from our peers and other experts on these sorts of issues is appreciated. So we're just looking for what may be helpful for us. That's perhaps a little bit selfish in a way, but we sort of are looking for the best advice we can, and we acknowledge that there are two quite distinct planning positions at the moment. So if we could hear back from the council team by the end of this week, back to me and the other commissioners, then we will consider that and probably put a minute together on this next week sometime.
Yeah, Commissioner Hamish isn't here. Yep, I'm happy to take that back to the council planning team and respond by the end of the week.
Thank you, Hamish. All right, back to you, Mr. Brophy.
Thank you, Mr. Chair. That's great. We'll look forward to hearing what council have to say around that point. So moving through into my evidence. So paragraph 14 of my reading notes there, and in terms of the Blue Haven submission, we have submission points on earthworks and signage are the two main areas. So we don't have anything on the other matters in this chapter. So the first point that I've provided some evidence on is in relation to the Earthworks Rule 12. And I've provided some evidence around the set parameter of 250 cubic meters of earthworks as a trigger point. And my evidence provided has suggested a method that relates more to the area of a site and providing for a standard which is 20 cubic meters per 100 square meters of the site within a 12-month period. So yeah, a point of difference there, I guess. Moving through into, what have we got there? Yeah, so the next point there in paragraph 15, again, is another standard relating to the cut height. Standard in the proposed in the plan. So I've got there in my evidence in chief, my suggestion is that a more efficient method of addressing cut height is to relate it back to instances where building consent is required. And on further review of the proposed rules and standards in Earthworks Rule 10, attempts to provide for this. However, if earthworks for a building activity require a building consent, this still provides no exemption to the earthworks effect standards, and consent will inevitably still be required if earthworks is for a building platform and the cut height exceeds 1.5 meters in height. So yeah, I've got some concerns there just with the layering of the permitted standards and a suggestion that potentially earthworks standard 2 should be deleted in its entirety or a clear exemption be provided for earthworks that are related to building activities where a building consent is required. So that's the earthworks side of things.
Perhaps it's good to just, seeing you are moving to quite a different topic, just to perhaps ask you some questions about the earthworks matters on the way through.
Sure.
Just, I presume your 20% suggestion is just relates to the industrial zone. Is that the way the rules would work?
Just
your paragraph 11 in your evidence in chief.
Yeah. So it's relating to commercial and mixed use zones. So
Okay.
yeah, yep. I'll just bring it up.
I'm looking at your paragraph 11 specifically.
Yep. These. Yeah, so actually there's that's probably what's confused me. So I'm talking about rule 12 in there, and I think I've referenced S12, earthworks S12, which is actually a typo. So that's in paragraph 11 of my evidence in chief. So if that could be changed to EW rule 12.
And is that in your appendix?
Should be in there.
Oh, yes, EW rule 12.
Yeah.
So that's covering quite a few zones, isn't it?
It is, yeah. So it's covering, yeah. Yep. And so I guess the Blue Haven submission is premised on the site being in the commercial zones, being a sub-regional centre.
So would you accept that this change would have broad application if accepted?
Yes, yep. And that's the intent of the change as well. I think I've noted in my evidence there that a lot of these areas do require often substantial earthworks for larger sites.
Can I just jump in there, Mr. Brophy, because it's a matter I just wanted to test you on. R12 is for earthworks not otherwise provided for in this table. If you go back up to the earthworks table, you look at R10, earthworks for building activities. Is it your view that the earthworks you're contemplating for your client here would not fit within rule R10 and therefore would default to the R12 rule?
Yes, I'm just thinking back to the submissions we placed on it, and I'm not sure we placed a submission on R10. But I think the what I'm saying there with the building activities, and I think I've talked to a little bit further down. So a few of these submission points, there's a little bit of crossover. But with the building activities, which is earthworks R10, which is the permitted standards for earthworks with building activities, you've got your set quantity, which is 250, and then you've got it in subsection 4 earthworks effect standards, which then teases out cut heights and a whole lot of additional points. So I'm just sort of saying it's not really covered yeah,
What,
and that the
what I think you're saying is that R12 would deal with general site earthworks prior to seeking a building consent, much like so you'd also have your regional plan requirements, which are not zone based, they're really just area and volume based. So this is a situation where it's prior to seeking a building consent and you're just working the site to get it ready for that. You then have a standard which is 250 cubic meters in a 12-month period, plus the effects standards are met. Okay, and then we've got instability of land. And you're saying, what else are you saying? You want two amendments, essentially. In your table at the back, you've got in any 12-month period, the total volume of earthworks does not exceed 20 square meters per 100 square meters per site. Is that right? So it's sort of like a 20%, a 20% of site area can be earthworked, plus the standard, which is the 1.5 and the 0.5, but then a note which says earthworks proposed in relation to building foundations, retaining structures, sealed vehicle access is excluded. Okay, so you want an exclusion in the standard for maximum cut depth and fill height. Okay. Presumably, though, the earthworks you're seeking to be excluded from that standard would potentially be earthworks that would be covered under a building activity anyway. So
that's correct.
I
think what's happened here is there has been, in drafting my submission, there has been a little bit of overlap between R12 and R10, and a portion of that I think is picked up by R10. So sorry, that's probably hasn't been too helpful in the evidence.
So, I mean, I can see what you're saying. I guess standard S2 would apply regardless of whether your activity is under R10 or R12, presumably. So it would be you're seeking an exclusion for earthworks in relation to building foundations, retaining structures and access, etc. Whether you're applying under R10 or R12.
R12, correct.
Okay. If you're applying under R10, notwithstanding compliance with the standard, if you exceed 250 square meters, then technically you'd need a restricted discretionary consent. Right? And if you're applying under R12, you're wanting the first condition of the rule, which is the volume changed to a 20% area, and also an amendment to the cut, fill and height. Okay.
The cut height, correct. Yeah.
Okay. All right. Now I get that now. Okay.
Yeah.
That makes sense. All right.
I think just to take that a little bit further, the thinking with, you could either run with the 250 cubes per site, or you could have my amendment. In the earthworks effect standards, by going back into your 1.5 meter cut height, you're essentially creating another trigger, whereas all the other effect standards tend to be about avoiding and mitigating effects, which is to do with sediment control and things that can typically be designed and provided for. So I just struggle a little bit with the layering of those, of the cut height and the volume control. That's the concern there.
Looking at this from the other way around, your client, you're seeking these changes to R12 and standard 2 on the basis that your client's property gets a zoning that would make it fall within a commercial zone. Is that right? Does your client have any broader interest in this? I mean, because we'd understood that your client had resource consent to do all the earthworks it needs. So to some extent, this is a bit of a moot argument, isn't it?
It is a wee bit, yeah. I mean, the earthworks is provided for. I guess it's partly just good drafting from what I'm seeing. And just covering base in terms of yeah, both that potential commercial spot there, or if it is to be maintained as an industrial zone, then that's provided for as well.
Well, you're not seeking any other changes to the earthwork to Rule 12 with respect to the general industrial zone.
Industrial.
Take it you're satisfied with the 1,000 cubic meters in a 12-month period there for the general industrial.
I think that is the case. Yeah, I can't remember a submission on that point.
Okay.
Yeah.
All right. No, that helps me understand where you're coming from. Thank you.
All right, I want to stay with your paragraph 11 just for a little bit longer to get my head around the zones. Like a lot of your evidence, Mr. Brophy, is on the premise that there will be a SRCZ coming through. But in terms of those submissions, and when we'll deal with the major Blue Haven submissions, we've made an assumption, or I've certainly, that most of that will be under the general industrial zone hearings. Will that also flow through to the commercial hearings and any other hearings, just with your knowledge of the way the hearings are being set up?
Can you maybe just rephrase that a little bit? I'm not quite sure what the question was. So in relation to earthworks?
No, this is not about earthworks.
No, okay.
My question is about, you've noted commercial, mixed use and industrial zones in your paragraph 11. So my question is, thinking ahead to how and where Blue Haven will present further evidence in seeking its relief in its submissions, is that primarily associated with the general industrial zone hearing? Will that touch also on these other zones?
The original submission does touch on industrial zone rules and also the proposed sub-regional centre. So there will be a little bit of crossover there.
But we don't have a hearing for a sub-regional centre zone, do we?
No, we don't. No.
So again, this is something that we might need to work with the council and its planning on, associated with, if we are going to be dealing with the Blue Haven submission in the round going forward for the main relief. Is that going to be heard under which hearing is really what I'm asking for? Any advice you might have?
Yeah, I mean, the submission points, a lot of them are on the commercial, on that sort of centres commercial zone portion as well. So I guess it could be included under that as well.
Okay.
But yeah, would be interested to hear what the council planners consider for that as well. Best way to manage that.
And certainly Miss Julie's involved in planning ahead on those matters too. So that's just a by the way, I think, in terms of your specific evidence. All right. I think we've traversed everything I wanted to talk to you about through Mr. or Commissioner Littlejohn's questions. So perhaps moving on to signs. Thank you.
Okay. Yeah, so paragraph 16 of my reading notes there. So yeah, the term architectural feature has been covered in my evidence, and which is included in sign R6. And in my view, the use of that term doesn't provide enough certainty in interpreting what an architectural feature is. So in my view, permitted rules need to be clear and readily easy to understand and comply with. And the use of this word does not provide this. And in my evidence in chief, I reference some case law where there has been conflicting interpretation of the word architectural feature. And the courts have provided some guidance on what they consider a permitted activity condition must achieve, which I consider provides some quite good guidance on this. Therefore, in my opinion, the word architectural feature should either be deleted or replaced with another term that provides more certainty and is not as subjective. Yeah. So moving through into paragraph 17, on to do with sign S7. So the definition of sign is supported, which includes the frame of the sign and any ancillary equipment whose function is to support the message or notice. And the face area therefore encapsulates the sign frame, which considers the performance standards. So this one is in relation to freestanding sign height and area. And I do support the section 42A author's recommendation to increase the height of freestanding signs from 3 meters to 5 meters, as well as the related increase in face area from 3 square meters to 5 square meters. However, with this in mind, I also do support the Blue Haven submission, which is seeking a maximum height of 8 meters for freestanding signs. And if the commissioners are of a mind to accept an 8-meter height freestanding sign height, then in my opinion, the face area should also increase. And I've suggested there that potentially a 2-meter wide sign would be appropriate for an 8-meter high freestanding sign, which provides for 16 square meters. And I've provided some commentary in my evidence in chief of why I consider a slightly larger sign could be appropriate. Moving through to paragraph 18 on sign S11. In my opinion, signage attached to buildings should be promoted ahead of freestanding signage for the reasons I've outlined in my evidence in chief. In the operative New Plymouth District Plan, over the years, there has been a reasonably permissive regime with regard to signage. For example, in the Industrial C environment area, which is the Blue Haven development site, the only standard with regard to placement of signage on buildings is that they shall not project above any part of the roof of a building or the highest point of a structure. So they're currently quite open. And I've also attached the consented signage plans to my evidence in Appendix A for reference for the commissioners. There's currently no restriction on the size or percentage of a wall line that a sign can cover. And in my view, the existing rules for signage in the business B and C environment area, with permitted standards of signage being able to cover 40% of front facades of the buildings, has achieved a good balance between allowing commercial signage and requiring resource consent for assessment. So my planning evidence is that the rules perhaps should be tightened up beyond what there currently is, but they should be providing for a relatively permissive amount of signage on the sides of buildings. Moving through to paragraph 19, signs rule 13. So I support the changes in the 42A report, looking at changing the activity status from non-complying to discretionary for the zones that are outside of the city centre zone, one of which would be the sub-regional centre zone, which Blue Haven are seeking. Commercial and retail sites such as the Blue Haven development site, in my opinion, are an appropriate location for third-party signage. given its location adjoining the state highway and the lack of adjoining activities that are sensitive to the effects of commercial signage, noting that the Blue Haven site is opposite the Valley Shopping Centre and a mixture of other mixed use and light industrial type activities that are not sensitive to signage. And as a point of comparison, I've included a table in my evidence that identifies activity statuses for a number of comparable zones in the Auckland Unitary Plan. The table indicates that these signs are typically restricted discretionary or discretionary activities in centre type zones, not non-complying. Through to paragraph 20 there, just another point there, supporting the caucusing between planning experts to consider the existing environment for signage through that existing consent that's been granted for the Blue Haven development, and how that would provide for the suite of sub-regional centre zone provisions generally. So that is supported. And then the final point there, paragraph 21, support Blue Haven's submission around sign standard 14, which is to do with digital signage. And again, perhaps this matter might be best addressed through caucusing, but I guess the key to that submission was the fact that there can be digital signage which can be, with new technology, can be seen through. So it can be attached to facades, and there was just some issues there with the drafting and the proposed plan enabling that. And that's my evidence in summary. Yeah, happy to take any questions.
Yes, thank you, Mr. Brophy. I'll kick off. Just on that last point about caucusing, we would be going through the witness conferencing if we do decide to go ahead, where there's some pretty clear expectations about what we'd be requiring. And this probably comes to a resourcing issue for the council. We're suggesting that there may need to be a number of the council planners involved, because obviously there's different subject matter experts dealing with those. So that's just an observation, Mr. Wesney, you'll need to think about when you consider this with the council team. Look, I do have an initial, I think it's a drafting mistake to start with in your table. Under sign R14 in your appendix B, I see there's a sub-regional centre zone there that doesn't look like it's been inserted. That should be in red, I take it. Is that right?
Sorry, I'm just bringing it up here on my screen. It's not quite the same without having the hard copy. What was the reference there?
Sign R14. Rule 14.
14.
Just my point is that the sub-regional zone, that's not being proposed by the council, is it?
That's correct. It should be in red. Yes, that is a drafting.
Yep, just a copy and paste with other things.
Yep.
Yep. Okay. Right. Thinking about signs, my first question is at paragraph 20. These buildings, that large modern glazed buildings incorporating digital signage into the architectural design. Do you have local examples, other examples you could think about?
I wouldn't say there's any examples that I can think of in New Plymouth. given that we don't have too many large modern buildings that have high levels of glazing. But I think there probably would be some examples in the larger centres, and we could possibly get some examples of them for you.
No, it's not that important. I just wonder whether you had your own experience to be able to make that point.
Yeah, I mean, the point of reference there is in working with the Blue Haven architects, we did originally consider some options for digital signage. We didn't end up progressing with them, but it was certainly feasible for what could have been done.
Okay. All right, another examples question about your paragraph 25, where you say at the end that these panel signs are nationally occurring design, and the maximum height of 5 meters is not sufficient. So a couple of specific questions. Other plans, other experience you have that go to this 8 meter height? Question number one.
Yeah, that's sort of more of a general observation. It isn't really a reference point on other plans using the 8 meter height. And it's in response to some of the work I've done locally here, where those sort of larger signs, and often they're freestanding panel signs which have multiple tenants listed on them. And I guess the reference point is sort of what you tend to see with petrol stations as well. They tend to be larger signs, and in my opinion, I just wonder, what would the concern with 5 meter height be if it was in a commercial zone area where they're expected and generally accepted, and it's something that we do tend to see throughout the country. And I'm expecting a number of those large panel signs will have triggered resource consent. But yeah, and inevitably that's what is constructed. So that was the frame of reference there.
Okay, certainly I am familiar that with many cases I've heard where there's been a lot of discussion about the size of signs. Just again looking for your experience here. Right, moving on. I've made the point about caucusing. No, that's all I have at the moment for you, Mr. Brophy. I'll hand over to Commissioner Littlejohn.
I just wanted to, excuse me, go through your appendix just so I can understand where each of the suggested changes come from. So if you've got that open there, we've done the first one I wanted to just check to see whether you'd picked up. It comes to this point about architectural features. And I mean, I do accept the point you're making that having things within rules where there might be debate amongst experts as to what they are or not, or even amongst non-experts is not ideal. And so I take on board your suggestion about sort of thinking about the use of that phrase. And I know the council have also talked about it in their 42A report. You've suggested that we take out item 2 from rule 6 because it mentions architectural features. And I just wanted to see whether you'd picked up that the same phrasing is also used in rule R5. And I'm just wondering whether that is something you'd also consider to be an issue. This is in rule R5, signs on or attached to a scheduled heritage building or item. So it uses the same condition there in the permitted activity.
I would say I haven't picked that up, primarily because my submission relates to modern buildings, I guess, that Blue Haven will be constructing. But from a planning point of view, I think the points I've raised equally would apply to heritage buildings in terms of the way that you'd interpret the use of that word, and that it is a bit uncertain.
Okay.
But yeah, haven't made specific submission point on that other one.
Flick through to sign S2, standard 2. And in the temporary signage proposition, you've added in signage on construction hoardings is permitted. And I am familiar with, I think the concept that was talked about, it might have been in the 42A report, or it might have been your evidence about hoardings around a construction site where you have graphic images about what's being built and the development history and the site history and things like that. And they're they're actually quite an interesting feature for pedestrians. And I say that from walking around Auckland at times where the CRL is being built, and very big hoardings with lovely graphic images about what's going in, just to create interest for the passers-by. So I think as a general proposition, I'm on board with you there. Do you think, though, that there's any need to be clear about what sort of signage might be going on construction hoardings?
I do. And reading through the 42A report, I agree with some of the reasoning they put in there, that the construction hoardings do, in New Zealand anyway, do tend to be from the contractors. And it is more advertising rather than educational or informative type signage. And yeah, I completely agree with you. There's some good examples in Auckland, and I know from traveling overseas, I've seen it around historic buildings, and is really good for pedestrians to engage with the development. So yeah, I think there could be some changes there, but in terms of my evidence, I've generally settled on agreement with 42A report, and that they are typically construction type advertisements, but if there was something there that could be amended to provide for more of an educational or historical narrative, I think that would be good.
Well, I think the key, and if we're using metrics the plan is using, the key is that it's not third-party signage, isn't it? So it's not actually being used as a temporary billboard for third parties during construction. It's got to be used for what's happening on the site in a way, and that could either be the construction companies, the contractors, or for another example is if the development is of a new apartment building, and the developer of the apartment building has got lovely graphic images of the mock-up of the apartments, and the sign only 5 left now, and sort of using the hoarding as part of an advertising proposition for it. Yeah, but I think what I'm asking you is you think it should be, if there's going to be any signage on a temporary basis, it shouldn't be third-party signage. It should be signage that's related to the site and the development itself.
Yeah, I'd agree with that. I think I follow the recommendations in the 42A report, which sort of signal that, but don't quite go further that you've suggested. But I'd agree with what you're saying.
Can I just come in on that? Sorry, Kit. So I'm familiar around town here anyway that the construction companies now regularly have right around the perimeter sort of netting type signage, which has their logos and stuff all over that. Is that what we're talking about here, or is hoardings actually defined? Would that be permitted?
Yeah, so my reading is that there's sort of two parts to this. Yeah, you've got your perimeter security fences, which can have construction advertising on it. So the way that the wording is that potentially might trigger consent. But if we've got our second other alternative is if it's educational or not third party and relates to the site, and that would be different. That's my understanding on it.
The council team might reflect on that. I don't have anything particularly personally against those sorts of things, because And they certainly are there with the intention of advertising the construction companies, without doubt. Some of them can be nice looking, others can perhaps be a bit garish when they're around for 2 or 3 years. Okay, thank you.
Okay, back to the only other thing I really wanted to talk about, sign 10, standard 10, sorry. Presumably the reference to the sub-regional zone or the cross-reference to the actual legal description is something. What I want clarification. Why have you put that there?
Could you guide me to which section of my evidence, please?
It's right at your appendix. I'm going through your appendix at the tail end, and it's where you've added in. I'm looking for I'm looking at the red comments, and I'm at sign S10, standard 10, illumination of signs. It is, and this is a standard that applies in all zones, and it's other than digital signs. And you've got a reference there to the sub-regional zone. Is that, and I'm wondering why it's been included there.
Yeah, I mean, that's been pulled through from the original submission. I guess it was something added to sort of give us broad scope, I guess. The reference to sub-regional zone was added in quite a few sections.
But you'd accept that if this standard applies in all zones, it won't really matter whether you
I
need
see
to
what
have
you
a.
mean. Yeah, yep, correct. Yeah.
Okay.
So yeah. Yep, agree with that.
It's not necessary. The next bit that you've done here is you've altered standard 1, all internal illumination or external lighting of a sign must, and you've changed the luminance and the timing that it must apply. Is that, I'm just, from your evidence, have you identified any technical basis for that change?
I haven't gone into that in my evidence.
Where did you pull those numbers from?
Yes, I mean that the Blue Haven submission was a group piece of work, I guess. So I did assist in drafting it, but it wasn't just my my opinion, I guess. So we did have some other people that had expertise in digital signage that had provided some advice on that one.
Okay, but you're not a lighting expert, are you?
No, I'm not.
All right. Okay. All right. Let me just think. I think that was it, actually. Yeah. No, those were the only matters I wanted to clarify. Thanks, Mr. Brophy. That's very helpful evidence.
Yes, and thank you very much for your assistance, Mr. Brophy.
Thank you. Thanks, Commissioners.
It's now 12:18. I think we will take our lunchtime break, acknowledging that we have Casey and Sarah on after lunch. Maria, Marlene, are you still planning to say something if you're listening in?
No, I don't have anything relevant to say, really. Yeah, so I'm fine.
Okay, and we are going to be hearing from Manu too, I think. Is that right?
Tane
Manu.
Manu.
Sorry, Tane Manu. Sorry, apologies for that. So have a good break, and we'll see those that are coming back at let's say 1:45. Sorry, 1:15. Sorry, 1:15.
Commissioner Cam's just released his video, so he may have something he wishes to raise.
All right, thank you.
Thanks, Julie. Yeah, I do. Yeah, just coming back to that conversation about the caucusing for Blue Haven, they have been in touch with me just in the last few minutes, and they just wanted me to add that a memorandum of counsel for MPDC was filed at the end of July, agreeing that they were willing to undertake a pre-hearing meeting and also engage in expert caucusing.
Okay, was that the one that was associated with the interim guidance?
Yes, the strategic direction hearing. Yep.
Right.
Yep. No, that's correct. That was from Lauren Wallace. Yeah, I do remember that coming through.
Yes. Okay.
Yeah.
Well, we may already have the answer there. So
yeah, and I believe, Julie, that you're sort of working in the background to make that happen. Email correspondence.
Okay, I'll check with Sarah.
Okay.
Let's just hold on line. I'll just double check while we're here. About advice we have received. So this would have been to do with hearing 1, is that right?
Yes, that's right. It was filed on the 29th of July from Lauren Wallace with the commissioners.
Okay, I'm just opening up what we got from Lauren. I've got one dated 30th July, maybe. We'll follow that through and see that we've got it. And but thanks for that. Thanks for that. Alerting us on that.
Thank you.
Thank you. All right, we'll see you back at 1:15, everyone. Thank you. Welcome back, everybody. Just thinking over lunch break about that notice or memorandum of council from Lauren. Have we had any further updates on that? I've had a look around my systems and I can't find that 29th of July memorandum. Is someone on council can either follow that up or enlighten me?
Hi, Commissioner. I've just forwarded the memorandum through to Julie, so hopefully she can forward that on.
I'm not saying we haven't seen it. There's been quite a lot of toing and froing, as you might imagine. But the main thing is we do get hold of it. Looks like Kit may have a copy.
Is it 29 July? Is that the date? Yeah, I did have it and I read it. And
okay, that's something I've missed. Then we'll have a look at that and certainly issue a response early next week.
yeah, if I can, what Ms. Wallace says is Council understands that Council for Blue Haven is agreeable to the above process, which is deferring the submission until later, with amendments being possibly made as a consequential amendment or during the plan integration hearing. Council also consider that a pre-hearing meeting between the Council and Blue Haven would be appropriate so that both parties can discuss and agree on the issues for determination. Both parties are also agreeable to arranging for their expert witnesses to conference and prepare joint witness statements prior to the hearing to help narrow the issues in dispute. So I don't read that as saying a general agreement to caucus on what a fully worked up zone might look like. But we can have a chat about that offline, perhaps, Mr. Dash.
Yes, and we'll involve Commissioner McMahon in that. And as I said, we'll give a commitment to come back to the parties early next week.
Okay.
Thank you for that. All right, back to our order of business. And I'm looking for, here we go. So Casey, Bellamy and Sarah, it's your turn, I think.
Kia ora, tēnā tātou. I ngā kai kohimana, Stephen, Kit, tēnā korua anō. I te iwi whānau mā, tēnā koutou anō, ko Sarah mako aho, ko Casey Bellamy tira. E mahi ana māua ko Casey ki te koteitanga o te Atiawa, he pautai ao māua nō reira. Kia ora koutou. So thank you again for the opportunity to speak with you. So today I'm speaking to the earthworks matters, and Casey, my colleague who's also online, will be speaking to the noise, light, signs and temporary activities. I hope you can hear me okay. I'm recovering from a cold, so you can hear me. Okay, cool. So I just wanted to mention a couple of matters in terms of our evidence. So I did assist with the preparation of the submission by Te Koteitanga to the proposed district plan, and am aware of the issues faced in relation to those matters which Casey will speak to. But I just wondered, are you happy? Is there a particular order that you want Casey or I to go in, or you're happy for me to speak first?
Whatever you'd like, we're totally in your hands.
Okay. So through part of my evidence, I'm actually going to call on Chris Marsh as well from Ngāti Rāhiri while she's on, if that's okay with you, but I'll get to that point. I may present my evidence and then ask Chris to speak. They will be complementary.
That will be fine. Thank you.
So I also wanted to just let you know as well that about my first role as a graduate planner was at New Plymouth District Council. So I was actually involved in the monitoring of resource consents associated with petroleum activity in the New Plymouth District. So I know there's been some discussion around that. So particularly in regards to compliance with noise. So I'm also happy to briefly share my experiences about that at perhaps once Casey's presented her evidence as well, if you think that will be useful.
And have you reflected any further about involvement in the airport discussions we talked about yesterday with Ms. Longley and Mr. Wesley?
Not at length. I guess when I think about Te Kotai Tanga submission and also Puketapu Hapu, the Te Atiawa Hapu with Mana Whenua, that we do have submissions in opposition to the airport zone, the special airport zone, but that was as far as I had really thought about it. I know that there was obviously a discussion around the realignment of the runway yesterday, and that is an ongoing discussion for Puketapu. That is my understanding.
Yes. Well, I think just touch base with the council and Ms. Ongley, perhaps, and it will be around scope with the matters that they're looking at, which is really the scope and what might be able to be put in the plan around the noise contours and the special standards associated with airport noise and land use. Yeah, but again, I'll leave that in your hands with those other parties to work out whether you participate or not.
Yeah, sure.
Thank you.
Thank you. So the main point I wanted to summarise from my evidence today is the impacts of earthworks on unscheduled, unknown, unmapped sites and areas of significance to Māori and other historic heritage. I understand from the advice of Ngā Hapu o Te Atiawa that earthworks are some of the most destructive activities to SASM. I'm going to refer to them as SASM through this, if that's okay, and other historic heritage. And our whānau hapu iwi, my tuakana kui and Kaumatua have experienced this through the last 2 or 3 district planning, town planning schemes. So as mentioned earlier, Chris Marsh, Ngāti Rahiri Potaiao, who has many years of experience on the ground for Ngāti Rahiri is going to speak to some of their experiences on the ground, if that's okay. And perhaps it would be okay if Chris spoke to that after I finished my my evidence, if that's okay.
Yes, so she's speaking in support of your proposals as a support person. Is that's right?
Yes.
Yes. Okay. No, that's fine with me.
Cool. Okay. So because of the vast areas of Māori settlement in Te Atiawa Rohe and the incomplete archaeological record, it is reasonable to expect that unscheduled SASM and other historic heritage will be discovered/rediscovered during all earthworks in the district. The scheduled SASM account for only a small portion of the Te Atiawa history on this whenua and the activities and events associated with those SASM in the cultural landscape. It is important to note that a SASM, irrespective of whether a SASM is scheduled, the objective and policy direction of the plan must apply to all SASM as their protection from inappropriate activities is a matter of national importance and a strategic direction of the proposed plan. Further to this, the removal of cultivation from the earthworks definition essentially makes a currently unregulated activity that contributes further to the continual destruction and disturbance of SASM and historic heritage a permitted activity. So just on that, you would have seen in my evidence, we've given an example of Mahue Tahipa, which is just north of Bell Block, where that is one particular site where cultivation happens annually, and it is only a small portion of the pa on the top is protected from that, from those cultivation activities. It is worth noting here, and I'm sure it will be discussed through further chapters, that not all SASM and other historic heritage is scheduled because the evidential threshold for scheduling is high. Those SASM and other historic heritage in the proposed district plan have been through an archaeological site validation, taking it beyond a heartfelt belief. The lack of scheduling in a plan does not reduce the significance of a SASM as mentioned before. A SASM is a SASM irrespective of if it is scheduled, and it is important that this plan accommodates this. It is my opinion the policy direction of the earthworks chapter conflicts with and undermines and has the potential to undermine the policy direction of the SASM and historic heritage chapter. Emphasis is placed on the possibility of avoiding effects only, as opposed to the protection of SASM from inappropriate activities. These following relevant policies provide more scope for this protection from inappropriate activities rather than what is detailed in the earthworks P4 policy. So SASM P2, so these are in the sites and areas of significance to Māori chapter. So SASM P2, SASM P5, and also in the historic heritage chapter as well. So P3 and P8, they actually relate to buildings, and then P13 and P16 relate to archaeological sites. So sorry, I did forget to mention at the beginning that I will, I understand that Casey shared her speaking notes as well with Julie for you, and I'm happy to do this. I'm happy to share mine as well. Oh, you're on mute.
Thank you. So we actually have some markups of what you're seeking here in the earthworks chapter. You've asked for a deletion, I think, of one of the policies.
Yes, so just one of the policies to be deleted. I didn't prepare a marked up.
Yeah, but it's just that policy you're asking be deleted in this chapter.
Yes, yes, deletion of EWP4.
Yeah.
So, as detailed in my evidence to hearing 1 and as discussed during hearing 2, protection of SASM can be achieved in a multitude of ways. There are many recent examples of this, and just wanted to highlight this afternoon. You may have read in the, I don't know if either of you keep up to date with current affairs in Taranaki, but in the Taranaki Daily News today, you may have seen that the council themselves have just had a minor slip up and forgot that they're also subject to the SASM and the historic heritage rules as well.
I should read that over lunch, funny enough. Yep.
So I guess that's and I guess that's a little bit different. That site is actually on Pukeariki Pa, so it's on a scheduled site. But the resultant discovery, which required them to stop works, was only their trigger for that. So I guess what I'm trying to say is that, you know, where there isn't a scheduled site, that it's really important that that process for how that's going to be captured is really important. The archaeological discovery protocol as a tool to manage impacts on those SASM which are discovered, rediscovered, is, in my opinion, not the most efficient or effective tool. I understand from the experience of Ngā Hapu o Tiatiawa that the use of ADP processes have led to the physical destruction of SASM. In my opinion, there would, if a site was discovered or rediscovered, there would be no rule trigger in the proposed district plan for the protection of those discovered or rediscovered SESM, or the potential for an adaptive management approach of an activity in the event that there was that discovery or the rediscovery. Just a couple of things as well that I wanted to mention that have been discussed over the last few days was there's been a discussion around the increasing the volume of earthworks. So my understanding is that this has been proposed to align with the regional freshwater plan for Taranaki and the volume, the permitted volumes in that plan. So you may be aware the regional freshwater plan dates back to 2001. So in my opinion, it's outdated. It obviously doesn't give effect to the principle of Te Manawa Te Wai. So we are in the process of reviewing and informing what the new plan could look like, and that's just a process we're working through at the moment. So in addition to aligning it with the regional freshwater plan requirements, the regional freshwater plan doesn't give consideration to all potential planning considerations, such as the relationship of, including the relationship of Māori and their culture and traditions with the ancestral land, Wahitapu and Tonga. One other matter, further discussion has also been had around who will determine what is practicable. So the same discussion probably needs to be had around what is possible, as noted in the Earthworks P4 policy, and also in SASM P5 and the Historic Heritage P16 as well. So I've just made note here of the English definition of possible, so meaning capable of existing or happening, that is likely to happen, or acceptable potential. So when we think about what, I guess that the question is whether or not does possible mean practicable? Because then if it is practicable, then I would think that practicable has an element of feasibility. So there's that potential for it to undermine the protection position of SASM and other historic heritage, which does not align with the strategic direction of the plan.
I'll just jump in and say you've recently been assisted in that argument by a decision of the High Court on this very point about the difference between practicable and possible. And I must say your analysis of the difference between the two words is exactly that taken by the High Court judge. So you are right, possible is a very different creature to practicable, but it depends on the context. So that's a point well made.
Yes, and for that, well, sorry, I was just trying to mention that that is the position that we have under the operative district plan now. That's what we've, in my experience in the last few years, is that's what we've faced, is that it's more of a practicability rather than a possibility. So Casey actually has been dealing with that exact scenario recently, where an applicant has applied to destroy a site, an area of significance to Māori, and their main justification has been the cost of it. But Casey may wish to elaborate further on that. But anyway, that was all that really was my summary, and happy to take any questions, or if you'd like to hear from Mrs. Marsh now, whichever would help.
I think we'll just ask you some questions now, just while things are fresh in our minds. I was just saying to Kit what the name of that High Court case was. Can you?
Oh, it was the Tauranga Environmental Protection
Okay.
Society versus Transpower, I think it was.
Yeah.
Yeah. Yeah.
Okay, no, that's good. So, Sarah, there's quite a few questions I had when you were talking, and I've also marked up some questions on your original evidence. The first question is about the interrelationship between the authorities required under the Heritage New Zealand Act and the district plan. What's your experience of developers or people doing works in New Plymouth District looking to gain a general authority under the Heritage New Zealand Act as anticipating that they may be working in areas that are THASMs?
I'm only aware actually of one where there wasn't a scheduled SASM, but the advice they had received from the hapu was that there was a high likelihood that they would encounter artifacts, and that relates to a subdivision in Bell Block. But the example that I did give in my evidence as well was around the Somerset development, which I don't think that was a general authority, but it did allow for, from memory, I don't think it was a general authority, but I could check that, was that it did allow for destruction.
Just following on from that, you've used, I think, quite carefully the terms discovery or rediscovery in what you presented to us today. We've heard that, I think I've read somewhere that, and I've heard it before in hearings, the dislike of the term accidental discovery. And my understanding, and I'll ask you for yours, is that the dislike of that is that actually it's not accidental because there's works being planned. And I have been involved in cases where the Canadian construct with their Indigenous people talks about chance find procedures, just to get around that dislike of the terminology. So coming back to your use of the term discovery or rediscovery, you said it 2 or 3 times, I think. What's behind that?
Those SASM.
No, that's one the use of your words rediscovery as well as discovery, I suppose.
Yes. So those SASM have been there for many years. So there's other activities that may have happened, and that's what's caused their rediscovery. So say the Somerset example, where there were two koiwi were discovered, and a large mara, a garden complex was rediscovered. So they had actually, and I would need to double check this, but they had been infilled, so there was evidence of the backfilling of those mara of the gardens, and they had maybe a metre of soil above them. So they've become rediscovered because other activities have caused them to not be at the surface anymore. Yes.
Okay. No, and just on the topic of the accidental discovery protocols as a standard, you would have heard the evidence which I listened into but not participated in from Mr. Holswich. Is that is that a matter that you have got in your submissions as well, or is that not covered?
Yes, that was covered in my evidence as well.
Yes.
Based on advice from Ngā Hapu o Te Atiawa, so the Te Atiawa Hapu is that,
Yeah.
and Chris may speak to this further as well, is that each hapu have their own archaeological discovery protocol. The way that they will respond to a find within their rohe. And so I get through that kōrero that was had this morning as well, is that there's, maybe there does need to be reference to an archaeological discovery protocol, but I question whether or not there's whether a one size fits all approach is appropriate. And there was mention this morning that potentially what the archaeological discovery protocol looks like in the effects standard, is that just a minimum?
Sure, and my experience concurs with both you and Mr. Holswich that there are bespoke protocols that have been developed with input from different hapu, and I know also from working with archaeologists and other parties, they always sort of go back to the standard sort of process, but when it comes to the cultural elements of discovery, rediscovery, certainly the way the Heritage New Zealand Act is framed, it covers both aspects of archaeology and cultural values quite distinctly. Those protocols on the cultural values side, outside of perhaps the pure science of archaeology, are normally bespoke in my experience. So you would have heard Commissioner Littlejohn carefully go through the standard and think about the ways they might be able to be more adaptable to each hapu. So yes.
And I think just on that, in my experience to date with Te Koteitanga has been, we've really been pushing for the requirement for hapu kaitiaki to be on site to monitor all earthworks. So we've been trying to achieve that through both land use and subdivision consents as well. And that require and almost, well, not almost, and trying to secure them as consent notices through subdivision development as well.
And how are you going with that?
There's a varied approach to it from the council officers. So.
Okay. Right. My final question for you, Sarah, is around this impact of cultivation and the working up of soil and land. You mentioned you had some concerns, I think, about the proposals for increasing volumes, which I think, is that on the basis that you're concerned that more area could be earthwork cultivated, or earthwork, let's say that, and that increases the chances of disturbance?
Yes. And where is the trigger for tangata whenua informing those volumes of earthworks?
Okay. And those are being looked at as permitted activity standards, aren't they? So increasing the amount that's permitted as of right, when you wouldn't have any notice, for example. Yes.
Yeah.
All right. And the impacts of cultivation. So I presume you're talking about drilling and ploughing and disking and tilling and those sorts of activities.
Yes.
Are you still coming in a lot of those areas would have been cultivated for decades and decades, I presume. Are you still coming across taonga that are coming up through cultivation? Is that with the
I couldn't I can't comment on that. I'm not aware of of anything that's been rediscovered recently.
Yes.
But that is something that will be explored, I'd say, by our hapu in the chapters to come.
Okay. Well, thank you for that, and thank you for your evidence and your answers. I'll put you over to Kit now. Thank you.
Thank you.
Kia ora. I'm when I go out of shot, it's because I've got all my papers spread around me, and I go looking into things. So that's why I'm not listening to you, because I got my headphones on, but I'm just doing a lot of investigation as we go, so I can make sure I understand the issues you're raising. So I just wanted to follow on from Commissioner Dacia's discussion about cultivation, and just track this through a little bit. And I might prevail upon Ms. Lawrence, and if you're online, just to clarify something for me as well. So as I understand it, the way excuse me, Hort New Zealand have approached this is that they've said that they would not want the concept of cultivation to be caught by the earthworks rules. And I think the council came back in its 42A report and accepted that rule R2, which was land disturbance for gardening, planting, or any vegetation and or the construction or maintenance of garden amenities, was confusing. And so they've added into that an exclusion which says excluding cultivation, so that it's quite clear that cultivation, which is the disturbance of soil for the growing of crops and the like, is not covered by that permitted activity rule around land disturbance. And so I think that bit as much as clear. Then in the 42A report, it continues, and the council officer says that paragraph 137, I do not consider that rule EWR2 was included to regulate or restrict rural activities such as cultivation. So on that basis, the officer accepts the Hort New Zealand submission. And then she says at paragraph 139, cultivation would still be captured by the land disturbance rules in other chapters of the plan, such as in the sites and areas of significance to Māori chapter. So, which is really the next topic I really wanted to talk to you about. But I guess that the question that comes to mind, and it's something that I'd want Ms. Lawrenson to clarify, is the amendment to rule R2, is it R2? Does that mean that by default cultivation becomes earthworks not otherwise provided for, and therefore subject to rule R12?
Can you see me? It's a bit dark in here,
Yeah.
isn't it? Hello. So the cultivation, the plan, or the earthworks chapter in particular, is silent on cultivation, and is therefore a permitted activity, except for where it's captured by other rules in the plan. So the thought around including the definition was for cultivation was to give clarity to the earthworks definition, which specifically excludes cultivation. So we haven't, as part of the 42A report, removed cultivation from the definition of earthworks. It was not there.
So your rule R12, because of that terminology with earthworks not including cultivation, would by default mean that cultivation's not covered in the earthworks chapter?
No.
Okay, all right. Okay, well then, thank you, Ms. Lawrence, and that clarifies that. So that rule does not apply to cultivation. So then I want to come, Sarah, if I can, to the SASM chapter. I hate that acronym, I'm sorry. The sites and areas of significance to Māori. And just, I don't think I'm going to be sitting on that chapter, but one of the things that I'm interested in, given your claims that there's a conflict between the earthworks chapter and the SASM chapter, I wanted to get a bit more familiar with it just to understand this, because we've been the plan's been criticised for being duplicative of various things. So I wanted to start then at your paragraph 15, where I think you quite correctly note, this is in your evidence, that a SASM is not required to be scheduled or listed to be a SASM. And I think you can, I take that point from, for example, the definition of a SASM, which is very broad, and in the English translation, site and area of significance to Māori means a site or place the tangata whenua has or at any time had an interest in, and the site holds cultural or spiritual significance to Māori, including Wahitapu. So the key thing I take from that definition is that it's not qualified by a reference to Schedule 3. Okay, so the plan takes this term and makes it very broad. It doesn't matter if it's scheduled or not. If it meets those qualifications, then it is treated as a site and area of significance to Māori. We then go to the SASM chapter itself, and if you look at the rules in the chapter, they do qualify the definition, don't they? They qualify it so that the rules only apply to scheduled SASMs. So, and I presume you and other mana whenua and hapu will have submissions about that in due course, but taking the plan as I read it at the moment, we have the provisions in the sites and areas of significance to Māori chapter, which, as I read it, limit all land disturbance in those areas to fencing replacement and the grazing of livestock as permitted activity. And that's SASM Rule 1, and that any earthworks on or within 50 metres of a scheduled site would require a discretionary resource consent, unless it is for fence maintenance. So I guess my first question is, do you have a concern in the context of the SASM rules that where earthworks is referred to, it now excludes cultivation? Is that a link through that we should put together? Okay.
On this, just to further that, on the SASM chapter as well. So Te Kotaitanga has submissions around actually an overhaul of the rules.
Okay. Well, I guess to some extent this means holding over, which we are intending to do, all of these things until we've seen them, because the way these two chapters operate together is quite important, as I'd understood it, and hence why I was a little bit concerned around your proposal to drop policy 4 from the earthworks chapter, because as I understand it, that policy 4 is intended to manage earthworks that might impact upon SASMs that are not scheduled. And so if you take the policy out, then you really don't have a policy that manages earthworks in relation to non-scheduled SASM sites, which would mean you'd have to completely renovate the SASM chapter to make it to apply to non-scheduled sites as well. Is that where this is going?
So the objectives and policies in the SASM chapter don't refer to scheduled sites.
I know, but the rules do.
The policy direction refers to all sites and areas of significance to Māori.
Yep.
I think that if EWP4 was retained, it does need to. So EWP4 has similar wording to SASM P5 and also Historic Heritage P16 as well. But I don't know how you describe them. If are they questions or are they assessment matters? So in EWP4 points 1, 2, 3, 4 are worded slightly different to 1, 2, 3, 4, 5, and 6 in both SESM P5 and HHP16.
Yeah, yeah. I mean that's an excellent observation, because what you're saying is that the policies in the earthworks chapter can also be used to achieve the objectives in the SASM chapter.
They should.
Yeah. Yeah, because the objectives are very broad, but then if you look at the way the policies in the SASM chapter are, that they too then become very focused on scheduled. So those are so as in one of the methods to achieve the SASM objectives is the policies in the SASM chapter that relate to scheduled sites, but also other policies in other areas of the plan where there are non-scheduled SASMs, but there are activities that might adversely affect them. So that's where I think I'm still sort of struggling with why you might want to take out policy 4 as opposed to suggest a redrafting of it so that it aligns better with the SASM provisions.
I would be comfortable with it being redraft too, so to ensure it aligned with the direction of the sites and areas of significance to Māori chapter.
Okay. Right, well, that's something we'll have to think about.
And happy to prepare anything in addition as well, if you think that will be helpful.
As my thoughts listening to this, sorry to kick the button, is that certainly the council team will be listening carefully to this as well. So there may be some thoughts they have as well, given the question line. And certainly I'm very happy and open to the council team reaching out to other experts to assist with any further thinking. Just we're looking for the best outcomes. So sorry about the dispersion.
Okay. The it's a common problem with special resources that everyone knows are there but are not mapped. And one of the most frequent problems that one of the other resources we experienced this with significant natural areas, of course. So just because an area is not mapped and scheduled doesn't mean it doesn't meet the criteria for Indigenous, significance. And councils have in the past, well, some I've been involved in, almost have a 2-tier policy regime, which is the first thing we're going to do is identify, and then we'll have a set of policies that apply to those that are identified. But then we'll have a catch-all policy that deals with those that we haven't been able to map, which then require in any particular case an assessment at the time of any resource consent application, for example. And provided the resources in question meet certain criteria that are specified in the policy, then by default the same rules that would apply if you were scheduled kick in. And as I'm reading the SASM chapter, I don't think it's adopted that approach. It's very much said this chapter applies to stuff that we've identified, and that stuff that we haven't identified we will leave to other chapters to deal with. And that's exactly where I think your P4 is doing a lot of heavy lifting in the context of the earthworks chapter for quite a significant resource. Sorry, that's me just talking out loud. It wasn't a question. So that assists me to explain where you're talking about in terms of the conflict there. Okay, and I've talked to you about the cultivation issue, which I understand better now. So yeah, I'd be interested in hearing from the next. Who did you say you had with you, Trish? Was it?
Chris Marsh.
Chris, on particularly around issues of areas that are widespread cultivated for horticulture and instances of discoveries that have arisen through that sort of process, because that is, I mean, that really is quite an important issue, really. It's a form of earthworks that can uncover significant material that we're effectively excluding from any rules in the plan. So I'm just interested to see what the historic sort of situation is around that.
Sure. Is that
Okay.
to hear from Chris now?
Yeah, Sarah, there's one other comment I'll make, and this might help both yourselves and the council team. There has been some recent Environment Court cases by Judge Thompson to do with Hastings District Council, and there's a series of cases that went up to the High Court, I think, and back again. This was around the issue of Waihi Tapu locations and in the broader area around about, and land use controls in the context of a much larger area. So you might care to, if you haven't come across those before, dig those out. They're just very recent. So with that suggestion, we're very happy to speak to you, Mrs. Marsh.
Unmute. Tēnā koe. To answer one of your questions, Commissioner Dace, yes, there have been things found during cultivation. Within the last 2 years, we've actually had 2 ads being found. So yeah, it is still being found even today. We're dealing mainly with gas companies within this area that I'm in for Ngāti Rahiri. Archaeologists are not brought in by companies at will. We have to put our foot down for them to be brought in if we know that there is a specific area that they wish to go into and we know that there is something there. Otherwise, it's this accidental discovery protocol, it doesn't allow for hapu input. And the way Ngā hapu work within Te Atiawa, we're on site. So if anything's found, we're there. We have found ko iwi through our excavations, and it's immediate. It's for our hapu protocols, it's immediate urapa. So it's a 100-metre radius shutdown. You do not, even until we know what the ko iwi is, you do not want trucks or excavators or anything driving within a 20-metre area, which is what is stated in this policy at the moment. The need for the council to have consultation with Ngā hapu is of the utmost importance, because this policy that is written here does not work. For any excavations, we have actually, during an earthworks episode, we've actually been able to see, once the topsoil has been removed, where the farmers back in the old days, remember how they used to roll the ground to loosen the earth? We've actually been able to see that evidence. It's still in the ground. The artifacts, the sites of homesteads, cooking utensils have been found underneath the topsoil. It is still there today. So yeah, it's an important policy where we need to work so it works for everybody. We did a job beginning of this year. We've actually found an area for the hapu which is so significant. We found an area, the evidence of a pātaka. In the old days, our people would have 2 poles or 1 pole, and the building was built on top. So you had your house on top of a pole or 2 poles, and then they would get a 3rd one and, like a ladder, put it up and down. We found that evidence at the beginning of this year. So it's proving to us, once again, in an area. Now, we didn't even know that we were going to find this. This was a real accidental discovery. I've been doing archaeology for the hapu for over 30 years. So it's when we get to these sort of things, it's whether we call in an archaeologist or whether we deal with it ourselves. The council have never been involved. And that's why I found this policy very interesting to read, where it's got council, but nothing about hapu iwi. Whoops. So yeah, I do have big concerns over this accidental discovery protocol. Anything else you'd like to hear?
No, that's very, very helpful. Your length of experience brings to us some evidence that we wouldn't hear from other experts, and your expertise in this area is very important in terms of our listening and making decisions. So thank you very much. I don't have any other clarification points myself. Commissioner Littlejohn, did you have any point? No. So thank you for that. Appreciate that.
You're welcome.
Thank you. Can pass it on to Casey now, if that's okay.
Thank you.
Oh, thank you. Hello, commissioners. I'll just get up my notes. Yes. Thank you, and hello, Mr. Chair. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Hello, commissioners, and to everyone present today. My name is Casey Bellamy, and I am presenting planning evidence on behalf of Te Kotaitanga o Te Atiawa Trust in relation to their submissions on the light, noise, signs and temporary activities chapters of the proposed New Plymouth District Plan. In relation to noise, much has been made of the use of the notional boundary versus the site boundary as the raw trigger for measuring noise. The planning justifications for this being a reliance on NZS 6802 as being the predominant standard adopted, and the preference in that standard for the use of the notional boundary measurement location, unless there are special planning reasons to justify otherwise. All of the planning evidence and noise expert evidence from submitters provided to date has stated they are not aware of any special planning reasons for why you would move away from this trigger point. In my evidence, I would like to amplify the fact that there are special planning reasons for a boundary-based trigger with respect to Māori land and areas that are of significance to Māori, for example, Urupa and Waiitapu. Now, Māori land is a taonga of special significance to tangata whenua, which is passed down from generation to generation. As discussed in the first hearing, Māori land is a limited resource in the New Plymouth District. Approximately 10,000 hectares, or 0.43% of the land in the New Plymouth District, is Māori land. Despite the confiscation of Te Atiawa ancestral lands in the 1860s, Te Atiawa descendants have continued to maintain a living relationship and connection with their ancestral lands. However, confiscation, along with other historical actions of the Crown, have limited the ability to develop Māori lands in a manner consistent with the traditions and culture and economic and cultural aspirations of tangata whenua. This living relationship does not always include a building against which a notional boundary trigger point can be relied upon. There are numerous reasons which frustrate the development of Māori land, which will be discussed at later hearings around the Māori purpose zone. Noise and associated reverse sensitivities issues would exacerbate this. With this in mind, the reasonably anticipated future uses of Māori land, such as Marae and Papakainga, form part of the existing environment. In my opinion, this needs to be explicitly clear and reflected throughout the entire planning framework in order to efficiently and effectively achieve the purpose of the Act. Similarly, existing cultural associations and those existing sensitive uses in the landscape, which in our experience are excluded from the resource consent process in the operative district plan due to the lack of an existing notional boundary at the time the application is made, is a direct result of the simplistic understanding and statements made so far in this hearing with respect to our relationship with those sensitive areas like Waiitapu, Urupa, and other places of solace where we as Māori are able to be Māori. There have been sub-suggestions that moving to an activities-based plan and specific consent requirements for activities being introduced, for example, discretionary activity status for well sites, would alleviate some of these issues. However, I would note that by retaining the notional boundary as the trigger or measurement point specifically in these noise provisions, this may set a permitted baseline that any processing officer is obligated to implement, generally speaking, which could in effect retain status quo as noise impacts on us and our relationship with certain areas of the district. Application of reverse sensitivity requirements to noise sensitive activities on Māori land and Māori purpose zone land does not recognise the existing environment. It will impose restrictions on the use of Māori land in many instances, which in my opinion does not give effect to Tangata Whenua Strategic Objective TW10. The specific exclusion of Māori land, treaty settlement land, and Māori purpose zone land from noise S4 is sought as relief. This amendment will achieve vertical consistency with Strategic Objective TW10 and horizontal consistency with noise S12, which uses the site boundary method for measuring noise in the Māori purpose zone. In my view, these matters constitute a special planning reason, and for these reasons, I support the use of the site boundary method for measuring noise affecting the Māori purpose zone or Māori land. The use of the site boundary method recognises the existing environment, and in contrast, the use of the notional boundary in relation to Māori land is inappropriate as there may be no notional boundary at present. Ko Taietanga o Te Atiawa Trust has submitted on the Māori Purpose Zone chapter, thinking amongst other matters that wider areas of land be rezoned to Māori Purpose Zone. Most of these areas are located in the Rural Production Zone as notified. In the event these areas are not rezoned, it is my opinion that the plan needs to be clear that the site boundary method will be used for noise measurement for Māori land and treaty settlement land in the Rural Production Zone. And then a minor amendment is sought to include reference to the Māori purpose zone in noise S151 and noise S172. And so that was me for the noise. I can continue on to the light if that was preferable to continue on through with it all and then questions.
Casey, I think it's probably better to, as we did with Sarah, just take each topic as you finish it. So I'm still finding some of the references. So if Kit was ahead of me, he could start.
Yeah, I guess I just want to come back to your complaints with S3 and S4 and just make sure I've understood you properly. So have you got S3 and S4 there at the moment in front of you? Maybe just if you find them there. These the two standards apply a land use control for doing certain things in certain locations based on zone. Have you got those there?
Yep.
And so so if you see the way it's in 3 columns, in the first column, that's the zone that the standard applies to. And then in the next column, you've got the requirement, and then you've got matters of discretion if you don't meet them. So noise S3 provides a specific requirement for noise sensitive activities that might go adjacent to highways. And you see there that it only applies to land in the rural production zone, the rural lifestyle zone, the future urban zone, and the residential zone. So the Māori zone is not, the Māori purpose zone is not one of the zones that would have to achieve that standard. And I make a similar observation in terms of the second standard, which applies to railway corridors. So that's the rural production zone, the rural lifestyle, and the future urban zone. So, and then over the page, you then have the city centre zone, the town centre zone, and the local centre zone. So on the face of it, noise S3 is not a standard that would apply to Māori purpose zone. Is that Do you understand that?
Yes, yep, that was my understanding too. And that's,
Okay.
yep.
Okay. And then you move to S4, which is essentially the same sort of concept, but now applied for 3 very specific locations in the district, one adjacent to the airport, the other adjacent to the port, and then the other adjacent to the Methanex Motunui facility. So are there areas of Māori purpose zone land that are within the possible control boundaries for the airport, the port, or Motunui?
Yes, I'd say so. Yep, for all of them.
Okay. So in terms of your evidence then,
Ed, I think Sarah wanted to just elaborate on that.
mhm.
Only if it's
Sure.
okay. We've definitely got submission points to those properties or sites which should have a multi-purpose zone but don't. And there are definitely sites within those 3 areas that you've mentioned, Commissioner Littlejohn, that would be affected.
So this, I mean, this is quite a it's quite a novel issue, really, because essentially, I don't think what you're saying is you want standard S4 deleted. I think you want it so that it is excluded for application in relation to land that's zoned Māori purpose zone. Is that a better way of putting it? Because there'd be other
Correct,
land within
yes.
these contours that, and that's on the basis that at some point in time, the Māori purpose zone land may be developed for sensitive activities, and the owners of the land would not want to bear any additional cost to protect themselves from their noisy neighbours.
Correct.
Okay, so what do you say the noisy neighbour should do in this situation, given that they're already there? And I think this was Mr. Holswich's point earlier. Does the day the Māori purpose zone land is developed next to the port for Papakāinga, is that the day the port has got to get a lot quieter to not create effects on the new Papakāinga?
So that's where our existing environment comments come into play, and it's that those sensitive activities should be considered as part of the existing environment as if they were there already, because those although historical actions of the Crown and other confiscations, etc., have limited the ability to develop Māori lands, it's reasonable that those activities should have been there already. And going back to the noise S4, as the relief was sought, it was either the entire deletion of noise S4, which...
Oh yeah, and I see it here, paragraph 22. Yeah, I got that highlighted, so that's right. Okay. I guess one way to creates an interesting problem in a way for the 3 sites that effectively are developed already. I guess if you did exclude the Māori purpose zone land but kept the noise requirements the same, it would mean that the port or the airport or Methanex, for example, would then have to treat with the owners of the sensitive developing Māori purpose zone land to provide for the noise protection for them, as opposed to, so it really just shifts the burden of who has to cover the cost of the noise protection in a way, doesn't it? So I'm just thinking out loud here. Don't panic, anyone.
Yeah, and I mean, that seems more. Yeah.
Okay. I mean that's an issue I've not come across before, and it's a very, very New Zealand issue in a way, where you've got land that had been confiscated that has now been given back through settlement, and yet the world has changed around it in the time that it's been out of control of Māori. Mr. Holswich's point again this morning, really. Okay, well, I understand that a bit better now, and what could be sought there. So thank you for that.
Thank you.
Ms. Bellamy, I just I was looking at your evidence, and you had an Appendix 1 which marked up the 42A report proposals, and then just recently Ms. Strack has given us another version of that. I just wanted to make sure that, well, firstly, Commissioner Littlejohn has come across that.
No.
This was an email which included Casey's speaking notes and a further markup. And I just wanted to ask you some questions before we move on about that further markup. So Julie, did that get sent to?
Yeah, I've got it. I've just seen it. Yeah.
Yes. So again, this is what we've asked for in terms of the procedures for these markups to be provided. But Casey, you've added to this since your evidence, haven't you?
So the matters that I have added are relation to the minor amendments to include reference to the multi-purpose zone in, as mentioned in my speaking notes, but to include reference in noise S15 and S17, I believe it was. Yes. The amendments in terms of the yeah, that's the only
additions. Yeah.
And then also it's more so just a tidy up, really.
Yes,
because I quickly threw in those. I saw the hearing procedures at the last minute and then thought, oh yes, I better get those in with me. So,
but you cover all those points in your evidence, don't you? Yeah, no, that's helpful. So just because I think Kit quite often quite happily goes through the words. So I was just really just checking that he had those and just getting some background on that. Right.
Yep.
I certainly don't. Sorry.
No, that's okay.
Yeah. So I'm looking at my notes now, Casey, and thinking about your noise. No, I did make a note about the alternatives around S4 that you offered in paragraph 22. So that's given us a couple of ideas, and that's certainly good practice as an expert to suggest some alternatives. So appreciate that. But no, I think you should move on to your next subject. You need to
thank you. So in relation to light and considering the effects of artificial light, the existing environment also needs to be given consideration. This needs to be explicit throughout the planning framework. I support the inclusion of reference to cultural values in light O2, P2 and S1 as recommended in the section 42A report. However, an amendment to the wording is sought to reflect that the cultural values of the night sky are not limited to views of night sky. Artificial light affects the ability of tangata whenua to undertake cultural activities, exercise kaitiakitanga, and adversely affects taonga species. As tabled in the biodiversity evidence submitted by DOC, artificial light adversely affect native seabirds and other taonga species, and the ngā motu were identified as a significant habitat in Taranaki for seabirds. The ngā motu are of special significance to Ngāti Te Whiti Hapu, who have prepared a cultural values statement for Port Taranaki and the surrounding area, including ngā motu, which outlines their long-standing occupation and values associated with the area. Due to artificial light from Port Taranaki, Ngāti Te Whiti are unable to undertake traditional customary activities on ngā motu. Ngāti Te Whiti Hapu and Puketapu are the Te Atiawa Hapu with Mana Whenua over Port Taranaki and the New Plymouth Airport respectively. In the absence of engagement with Ngāti Te Whiti and Puketapu, I do not support this Section 42A report's recommendation to exempt light from aviation and aircraft at the airport and light from navigation and shipping at the port from light P1, P2 and R1. Although it is recognised that some light from these activities is necessary to enable safe operations, it must be recognised that artificial light from these activities creates adverse cultural effects. The existing environment must also be given consideration. In my opinion, the exemption as recommended needs to be tightened so that it only applies to those activities necessary for safe operation, which can be listed in a definition, or the exemptions removed in their entirety. The exemptions as worded would have the effect of prioritising the safe and efficient operation of the port and airport and the strategic objectives for urban form and development above the tangata whenua strategic objectives. Te Kotaitanga have also submitted on the port zone and the airport zone chapters. And then noise from Port Taranaki is now being heard in the port zone chapter. In my opinion, the effects of Port Taranaki should be considered holistically. Therefore, light from Port Taranaki should also be considered under the port zone chapter. This would provide consistency and clarity. And then another minor amendment is sought to move reference to the Māori purpose zone from light S121 to light S111. This will allow for the use of the site boundary method for measuring light, opposed to the notional boundary method, and apply a light limit of 10 lux, which would apply if the notional boundary existed on Māori purpose zone land under light S121. So that concludes the light summary.
I think we'll pause there again. And again, I'll ask Commissioner Littlejohn to see whether he has any questions.
I'm just catching up, sorry. I'm just trying to get to the provisions. So the last one.
Perhaps while you do that, I could just ask a spelling question. In your paragraph 11, you've got a definition there using the term Mouri with an M-O-U-R-I.
Yes. So that's
is that a local dialect? Is it, or?
I believe so, but maybe somebody else who's online would be able to advise in that regard.
Okay, with the use of the O, that's interesting.
Yes.
Yeah.
My understanding is that it's a dialect we use, Māori. Māori or Māori?
Oh, yeah, like Maunga, like the Maunga as well, because
I struggle myself with the pronunciation as well, and I've tried my best, but I'm just fascinated by the use of dialects. I think it's really useful if those are if that is a local dialect, that the plan deals with that in that way.
Okay. Okay. Yeah. Sorry. Thanks for letting me gather that one. The request to have light-related matters concerning the port dealt with at the port zone is something you should have probably signaled before the hearing in a way. I'll have a chat to the chair about it, but at this stage, the only aspect of the provisions that are district-wide that are being put off in terms of noise for the port zone, and I think noise in respect of insulation adjacent to highways and railway tracks. So I guess I'll ask the question: is this an explicit request on behalf of the trust to have light-related matters concerning the port zone and activities at the port deferred to that port zone hearing?
Not a request as such. It was more so highlighting that it would have been, in my opinion, more appropriate to deal with them all holistically. But I mean, yeah, I don't know. So it might be that we are requesting Te Koteitanga might want. I could get back to you on that. But, but yeah, as I understand it, it was more so just a point to be made, and that it would be preferred that all the effects are considered holistically.
Okay.
So I could probably make a comment now. We
Yeah.
we have had a specific request to defer the noise matters by way of memorandum, which we have agreed with, and that was circulated around all of the parties. That probably would have been the time, I think, to have made that request, because we are actively planning for that at the moment.
No, and that's fine. It wasn't just the point.
Yeah, we've got your views anyway, I think. Just on
Yeah, and I think it's a point well made about how far you go to exclude these very specific sites from compliance with general noise, with general light standards. So it's certainly an issue that's before us and we can consider. One thing I'm wondering if you could help me with is just give me some examples, if you can, of, where is it? The cultural values of the night sky.
So we've got so rather recent, well, can't say it's recent, but Marabataka is undertaken that requires the night sky, and then you've got Matariki and Poanga celebrations as well, cultural values.
Sorry, what was the first one? Can you just explain that to me? Maramataka.
So that's the Māori lunar calendar, and it was used to guide all manner of activities from when you were meant to gather harvest food, to gather kai from the sea, and those elements.
Yep. And I presumably I've got Matariki, that's well known.
So Puanga is the easiest star to see here from Taranaki.
Yeah.
Yeah, so those are values associated with the night sky. Certain hunting and birding practices would have been undertaken at night as well, and those are affected by artificial light.
And that's helpful, because I really wanted to try and get a sense of this. It really it aligns with, I guess, the general community expectation of having a very clear night sky and not interrupted with excessive artificial light. So it aligns with that sort of general general desire to want to be able to see the night sky and without excessive overspill of light. Okay. But to some extent, and I guess this is where I get down to the crux of your complaint here, is the brackets around view. You've got views of the night sky with a suggestion by staff, brackets including its cultural values. And I guess what you're saying is that the cultural values extend beyond just views of the night sky. Would that be the way to put it?
Yeah, that's correct. And there's there would be concerns that enclosing that in brackets would limit our cultural values consideration, which in relation to the night sky is not only views of the night sky. There's cultural values associated with the night sky beyond views of the night sky.
beyond being just able to see it clearly.
Yes.
Yeah. Okay. That's helpful. Thank you for that. Let me just see. Okay. No, I think that was it. Thank you, Ms. Bellamy. That was helpful.
Thank you.
I do have a couple of questions really about the, so the second preference for the light in your marked up version that you've just received through, you have a second preference in terms of these light policies. That's right, isn't it?
Yes.
Yes. And that second preference, for my read, includes an exemption for safe aircraft and aviation operations at the New Plymouth Airport and safe navigation and shipping operations at the port. Is that the difference?
Yes, that is the difference. And I've mentioned, I included this one, and I remember it being mentioned in the earlier hearings about this ambiguity around what safe operations for the airport and the port would entail. And so I thought perhaps you could include a definition in relation to what operations constitute safe operations in the district plan to cover those specific activities that are necessary for the safe operations of the port and airport.
Okay. And the section 42A report has quite a lot on this subject, and there are submissions and other evidence on this. So this will be just another alternative that the staff can have a look at when they come back to us in their right of reply. So that's why I said it's always useful to have another alternative. So I don't have any other questions, Ms. Bellamy, on light. So we'll move on to signs, I think, next for you.
In relation to signs, I support the recommended wording in the section 42A report in relation to sign P5. And an additional note is suggested in the chapter in relation to the engagement of cultural expertise. This was outlined in my brief of evidence. And then in relation to temporary activities, Kotaitanga are involved in several temporary activities, including those mentioned in my brief of evidence. Te Pūtaki o Te Rere, an annual commemoration to remember the events of the Taranaki land wars and the passive resistance led by Te Whiti o Rongamai III and Tohu Kākahi at Pariaka. Te Rao Te Maui Pōmari, an annual celebration of Sir Maui Pōmari, the first Māori doctor. Taranaki Tūmai, a biannual sporting event held between the 8 Taranaki iwi. Taranaki reo competitions are held annually at Ōwai Marae. And then if the WOMAD Festival is held annually in New Plymouth, and the performing artists are welcomed at Ōwai Marae on the Thursday before the festival begins. The planning framework will provide for these activities as a permitted activity, which is supported. And so, Nō reira, that concludes my summary of evidence. Thank you. I welcome any pātai or questions.
All right. Thank you very much for that summary. Again, excellent summary. And I particularly like the way you've put those possible questions at the bottom.
Yes, I think they might have meant to come out before I sent those through.
But it also the scope question, that's quite thoughtful, and there's nothing wrong with posing some possible questions like that and being prepared. So I think a wee birdie might have told me that this could be your first appearance as an expert, Anna, is that right?
Yes, that is correct.
Yeah, and
I should have asked some hard questions.
Yeah. And knowledge is a bit unusual in the circumstances. Normally you can get more out of just being in a room and talking kanahi to kanahi and get the vibe a bit better. So you've done very well, and I don't have any other particular questions on the two other matters about signs and temporary activities. I thank you very much for your participation and your evidence, and I'll hand over to Commissioner Littlejohn to see if he has anything else.
No, I'm fine. Thank you very much, and well done for your first appearance.
Thank you, Commissioners.
Yeah, kia ora, Sarah.
Kia ora korua. Thank you.
You were on mute, Stephen.
Sorry, I lost my mouse at the same time on another screen. So it's Maria Te Kahui Taranaki Iwi Trust. Welcome, Maria.
Kia ora. Tēnā tātou katoa, ko Maria Hokora au he pautaia mō Te Kahui o Taranaki Iwi Trust. Thank you, Commissioners, for the opportunity to speak to you today. Also want to tautoko what Matua Keith said earlier, and thank you to Julie and your team for all your support and work. It's been no doubt a struggle with all these Zoom challenges. It's also my first time appearing before a hearing giving expert evidence, so aroha mai if I'm a bit whakamā. So I'm speaking today to Te Kahui's submission regarding earthworks. So there's been a lot of work done by tangata whenua and council staff to map out sites and areas of significance to Māori. SASM, apologies, I'm going to use the acronym. And the Māori cultural landscape and its depth are quite complex. As I mentioned in my evidence, the Māori cultural landscape and SASM are a limited and precious resource, and due to previous attitudes and actions, much of this resource has been destroyed. And as Ms. Mako commented earlier, not all SASM are mapped or scheduled, and it's these unscheduled sites that are especially vulnerable. It's my understanding that the requirement to protect historic heritage from inappropriate development is not limited to scheduled sites. Scheduling is a tool which has specific rules for those sites. So scheduling allows specific rules to be attached to those scheduled sites, whereas the protection of all heritage from inappropriate development remains a matter of national importance. General activities and the rules which provide for them, such as earthworks or subdivision, and those for growth areas in particular, must consider the protection of historic heritage from inappropriate development more generally, while noting that there is an incomplete archaeological record within Taranaki. Te Kahui's submission is that EWP4 should be removed. It is my opinion that the strategic direction and objectives are more fully realised and better implemented in the policies set out in the historic heritage and SASM chapters of the proposed district plan. In my opinion, the inclusion of earthworks P4 introduces a lesser requirement for our unscheduled and unmapped sites. And as I read the heritage and culture and tangata whenua strategic objectives as set out in minute 9, they set a clear intention or direction to recognise and provide for tangata whenua, our unique relationship, and to protect SASM and other taonga. And that's not limited to scheduled sites. And also in my reading and understanding, this is a position supported and reinforced by higher order planning documents. And it's my opinion that EWP4 undermines this direction because as it is written, EWP4 and the rules which refer to it provide a pathway by which unscheduled SASM are able to be destroyed without a trigger for earthworks consent. And so I noted earlier, Commissioner Littlejohn, you were talking about how there were, in your experience, there's been the scheduled rules and then a catch-all kind of approach in some other plans where there's an assessment for sites where development is proposed and there's a resource consent trigger. I guess my concern, or Te Kāhui or Taranaki's concern, is that there is no resource consent trigger for a lot of these SASM, unscheduled SASM sites. And so even though this policy is well-meaning, I don't see how it has, how it brings about protection for those sites. And indeed, if it is referred to, there's no opportunity for adaptive management. And I feel like the policies in the historic heritage and SASM chapters allow for more of that adaptive management approach rather than avoid the effects, or if you can't, oh well, go ahead. So yeah, in the event that a restricted discretionary resource consent was required under the earthworks provisions, that would be because of the cut or fill or area standards being exceeded, or there would be instability triggers. And in my reading, EWP4 doesn't direct district plan users to consider the appropriateness of a development, or even advise users to engage with tangata whenua to determine if a site contains wāhi tapu or significant cultural values. And so it's my opinion that EWP4 is less effective than the relevant policies in the SASM and historic heritage chapters, such as historic heritage P8 or 16, or SASM P2 or P5. I note though that Te Kāhui has scope in terms of those sections, and so I'll leave that for later hearings. But I would like to note that of the 8 policies in the SASM section, only 2 are limited specifically to scheduled sites, whereas 6 of the policies refer to SASM more broadly, i.e. scheduled or unscheduled. This is important as paragraph 52 of the section 42A report posits that the SASM section deals primarily with scheduled sites. So while the rules in this section do refer to those scheduled sites, I believe the objectives and policies are more broadly applicable. I also disagree with Ms. Lawrenson's position in paragraph 55 that EWP4 is required to underpin the ADP standard in EWS5. Yeah, it's in order for a plan to be effective and efficient, it should understand the existing environment. And I don't believe that an ADP would address the issues present in the existing environment with respect to our incomplete archaeological record and the fact that not all of the sites are scheduled in the plan. The Heritage New Zealand Pouhere Taonga Act covers some of the aspects of an ADP, and based on the advice of Ngā Hapu or Taranaki iwi of Tangata Whenua, this hasn't resulted in the protection of SASM and Taonga, and in the event that an ADP process is followed, yeah, it's not a resource consent process. It goes through an archaeological authority process, which where there's different, I guess, different matters that are raised. It's not necessarily cultural heritage and cultural values, but more archaeological, which doesn't necessarily meet the needs of tangata whenua and hapu. Yeah. What else? If EWP4 is retained as per the Section 42A recommendations, we would have concerns also regarding the wording of the policy. And Sarah, Ms. Markor raised this earlier, the use of possible and then the suggestion of practicable, and how those are applied, or how the policy is applied, I guess. Yeah, and Commissioner Dace, you also raised earlier, like who is in previous days, like who's determining what is possible? How would that involve tangata whenua? If financial or costs and feasibility enter into those considerations, is this merely just a difference of opinion? If so, whose opinions? And if possible means possible, what does that look like in practice? And if possible is applied as meaning practicable, how does this actually align with the strategic objectives? Yeah. Yeah, so the matter of national importance is not where practicable, protect historic heritage. That wording puts the emphasis on whether something is able to be achieved, not whether the development is appropriate or not to protecting heritage. And so the practicable recommendation, or the inclusion of practicable as per, I think it was the oil company's submission, in my view, does not give effect to higher order planning instruments. Yes, that's all I have to say for now. Happy to take questions.
Certainly for your first hearing, very insightful and wise observations in your evidence and your summary. So thank you very much. I have a couple of introductory questions. One is about Te Kahui o Taranaki iwi, just your place in the world. I understand it's south of New Plymouth, but can you just give me a little bit of background about the iwi?
Yeah, sure. So Te Kahui o Taranaki is the post-settlement governance authority from, and Aotearoa is from Paratutu Rock, south to the edge of the New Plymouth district round the coast, and it extends into the South Taranaki district as well.
So the boundary, the Stony River, is being in the middle of your rohi, is that all the rohi is?
Yes, yeah.
Yes. And it comes around the mountain into South Taranaki or Stratford district, or?
South Taranaki, it goes to, depending on who you ask, around Pihama or Takio area.
Okay, great. Thank you for that. And I just did want to ask you some questions. You heard me talking about the interface with Ms. Mako of the Heritage New Zealand Pohiri Tonga Act 2014 and district plans. And having quite a bit of experience in working on these sort of issues for many clients, more often than not on anything that's substantial, we do deal with both acts where it comes to areas where it may be either there's recorded sites, scheduled, we'll use the S word, SESMs, or recorded archaeological sites. And there does seem to be quite a bit of an overlap sometimes, which I think district plans need to be wary about with running two parallel processes. I'm running one at the moment where both an archaeological authority is required and then a land use consent is needed. And the way the plan anticipates that in this case is that we need the archaeological authority before we go through the district plan process. That's the way that plan acts. But in the archaeological authority, when you do look at issues and effects, it's not just archaeology, it's Maori values as well, and including statements about whether there's been any consultation with tangata whenua and reasons, if there's been no consultation, reasons why not. So when I look at this general issue we're talking about here, earthworks that might affect sites for significance to Maori, we are dealing with two pieces of overlapping responsibility and legislation. So my question is, what's your experience with the interaction between the two agencies, the District Council, Heritage New Zealand, and the two pieces of legislation?
Very limited experience with archaeological authority processes. I used to work for South Taranaki District Council, and so I do have very limited experience in terms of the application of archaeological authorities. In that position, there was quite a disconnect between the district plan and the archaeological authority process, and part of the issue with that was that there weren't many recorded SASM sites, and so we would get subdivision or land use applications where iwi, we would be advised by iwi that there were sites of significance, but because they weren't scheduled, there was a very limited scope for council to intervene. And so they were quite, there was a disconnect there, which meant that unfortunately development was granted, or consent for development was granted, regardless of the fact that iwi knew that there were significant sites on that land, and yeah, so that's I guess the extent of my experience in terms of that overlap and that disconnect.
Yes, and would you think that the plan drafters, I'm thinking about the council team and submitters and us, we need to have in mind the interface between the two jurisdictions as we make our decisions and as we get advice on what's appropriate for New Plymouth District, thinking about the way both jurisdictions interact? Would that be appropriate in your view?
Yeah, I think so, because I guess so the authority process, in my limited interaction with that, is that it's permission to destroy or remove a SASM, whereas if it's a consent process, there's more scope, I guess, for adaptive management or for interaction, to see how a development might be suited to include that SASM, as opposed to just an archaeological authority where Heritage New Zealand gives the green light for that to be removed from the landscape. And so I think it's important to have both. I think both processes serve their purpose, but I think that the district plan presents a really great opportunity for historic heritage and SASM to be developed appropriately, or land that contains these sites to be developed appropriately. Yeah.
Okay, that's good. I want to ask you a question about EWP4, a specific question. So do you have that handy?
Yes. Yep.
And I've certainly been very interested and intrigued by what I've learned today about the linkages between the various chapters, of course, which we haven't delved into, the Maori Purposes Zone and the sites of significance to Maori, and the fact that there are policies, objectives and policies that cover a broader range than just the scheduled sites and the rules. So just thinking that in mind, the introduction to EW4 talks about, I'll read it out. Ensure earthworks are undertaken in a way that avoids adverse effects on archaeological sites. So those will be defined and mapped in the district plan, or presuming they are, and sites and areas of significance to Maori. So when you actually read that, do you read that as scheduled sites or all sites?
I would read that as all sites.
Okay. So it has that broad application, whether it's scheduled or not. That's the linkage as you see it. Yep.
Yes.
Okay. So that's certainly helpful. And again, you've heard my questions, I think, about the issues around accidental discovery protocols, whether one size fits all, the ability for hapu to be recognised in both their formulation of what they contain and how they operate. Are you of the same mind of the other witnesses we've heard about that, Mr. Holswich and Ms. Mako?
Yes. I guess my thoughts around that are there's still no resource consent trigger. So it may be a bit naive, but I don't imagine that people are going to, applicants are going to say, oh no, I'm not going to comply with EWS 5, so I'm going to get resource consent. at which point we could refer to EWP4. So I guess my reading of it is that unless, and this links in also with the volume and area of earthworks permitted, is that if unless there is an instability, cut and fill or area trigger, earthworks would be permitted. And if an ADP, if something was rediscovered or discovered, then there would be a process to go through, but it still wouldn't require resource consent, and there still wouldn't be that opportunity for adaptive management, and it wouldn't be the opportunity for Hapu to say, actually, you know, can we rethink this, or can we incorporate, you know, the site in a way that's going to be respectful of the site, but also lend itself well to development. And I suppose that's one of the concerns that I have with the way this chapter is set out, is that there's EWP4, while it's good in its intentions, I'm struggling to see how it would be applied to achieve the outcomes that I think it intends. Yeah.
That's useful. And is your read of EWS5 that it's a reactionary standard, only comes about if something's actually discovered?
Yes.
Or rediscovered? And your feel, which, am I right that your fear is not the right word, your concern is that A, tangata whenua aren't properly involved in that the way it's written, and B, even if you are, there's no control to make any difference. It's just perhaps a recognition, some prayers maybe, and some taking away of the taonga or the koiwi, and then things just carry on as they are. Is
yes,
that
that's correct.
what, yeah.
Yeah.
And I think I certainly agree with Commissioner Littlejohn when he says the interaction between this, the earthworks rules, the SASM, the scheduling is a very New Zealand, very Kiwi planning issue, which I've seen evolve in my own practice hugely in the last 5 years, particularly as post-treaty governance groups have come about and have had resources and have their own lands, more of their own lands, and certainly planners are being challenged by this more and more. So the interface, as you and as Marco have talked to us about, between EW4 and the other objectives and the other chapters that you're interested in, has certainly been very helpful making that linkage. And we will have to look at those matters in the round, and sounds like we'll be hearing further from you on those other chapters. So thank you for that. I've asked all my questions, and just hand over to Kit now.
I was just going to, I've just been reflecting on the same issue again, as you've been giving your evidence, because I had the same notes written on your brief. So I guess it's a tricky one, because well, it's not I don't guess, it is a tricky one, because the permitted activity requirement around the accidental discovery protocol is admittedly sort of ambulance at the bottom of the cliff sort of thing. So that even if a developer ignores it and goes ahead and does a whole lot of earthworks, and it is found out that said developer found some artifacts and did nothing about them, they could be prosecuted. I mean, that's the implication of failing to comply with a standard on it. By then it's sort of too late. And you end up then going through the criminal system with reparations and victim impact, and that's a whole other sort of story. The The only way to sort of avoid the situation, though, is to not have any earthworks that are permitted, isn't it? Or to have a standard that applies to earthworks that, well, you could have a range of additional standards. One could be that prior to undertaking earthworks, you notify the relevant hapu of the location and the place where you intend to do them and invite them to be present. Again, it relies on the goodwill and the relationship with the person doing the earthworks as to whether they are going to actually comply with that requirement. Yeah, it's a tricky one because this role is to deal with the things that we don't know that we don't know about. And the opposite, and other cases the chair was talking about in Hastings, were very much focused on this. This is unrecorded. This is potentially discoverable. So until you actually start turning the earth, you don't know if there's anything there or not. And so, yeah, it's a challenge because I take your point that you don't want to be at the end of the cliff, at the bottom of the cliff. You'd like to be there when the sod is turned, no matter where it is, which then brings in a whole other question around resourcing. Does the hapu have the ability to send a person out to watch everyone, digging a few cubic meters of earthworks for something, just to make sure that nothing is shown up? I'll be absolutely blunt. I'm not persuaded that getting rid of policy